Morning.
Item 1 or orders.
Yeah, please, Lordship. Lordship, conducting counsel, Mr. M. Hassan is suffering from viral fever, Lordship. Lordship, may kindly the peace meter after we.
Okay. Therefore, adjournment is made on behalf of the learned counsel for the review petitioner. Mr. Matter stands adjourned today. List as and when the which is next available. Why you are not doing the matter today?
I am not taking the taxable case, Lordship.
Or the advocates, you are not the counsel on record. Okay.
Item 2.
Lordship may pass over for the day, Lordship.
Well, this is not a regular bench. We can't just
Lordship,
one matter we have adjourned, but this is for the time being. Okay, because this is not a regular bench. It's very difficult to constitute one. CPC. It.
Item 3.
Lordship. My lord, we have challenged challenge means we have also review of the order of the Honorable High Court dated 10/5/2019 that may be seen page 20, my lord. What that, my lord, if your lordship
Just a moment. Just a moment.
That's my question. That's the question.
Yes, what is the error apparent on the face of record?
My lord, errors are, in a sense, my lord, all public documents which are even exhibited has been interpreted in a manner which has no sanction of law. For
But
instance, my lord,
that is prima facie a wrong decision. It has to go to appeal. We can't sit over appeal in our own order if there's a inherent mistake in the order.
My lord, the
It should be error
Supreme,
apparent on the face of record, not a incorrect consideration of the materials.
based on the record, that should be given a wider meaning. Because the Honorable
but-
Supreme Court has come in several
No, that's
decisions.
okay, but has the Supreme Court says that even if the decision is erroneous, you entertain a review.
Lord, I will satisfy your lordship on these points. My lord, that is 2005, 4 SCC 741 citation.
2000,
2005,
yes.
4 SCC
No.
741, para 88, 89, and 90.
What is the name of the parties?
Name of the parties, my lord, Board of Control for Cricket in India.
Okay. Yes. Please read it.
My lord,
read it
para
very-
88, 89, and 90. I am reading, my lord. Para 88. We are furthermore of the opinion that the jurisdiction of the High Court in entertaining a review application cannot be said to be expressly bad in law. Section
You
114
are
of
reading
the,
paragraph?
my lord,
You are reading which paragraph?
88.
88. Yes.
We are furthermore of the opinion that the jurisdiction of the High Court in entertaining a review application cannot be said to be expressly bad in law. Section 114 of the court empowers a court to review its order if the condition precedent laid down therein are satisfied. The substantive provision of law does not prescribe any limitation on the power of the court except those which are expressly provided in section 114 of the code, in terms whereof it is empowered to make such order as it thinks fit. Order 47, para 89. Order 47, Rule 1 of the code provides for filing an application for review. Such an application for review would be maintainable. My lord, this is very important. Would be maintainable not only upon discovery of a new and important piece of evidence, or when there exists an error apparent on the face of the record, but also if the same is necessitated on account of some mistake or for any other sufficient reason. Now, for any other sufficient reason, that, my lord, section 21 of the IPC, those have mentioned the public officers. Now, the
21 of the IPC.
IPC. Now, of course, it is IPC 21, it may be an estimate also.
In a writ petition, IPC is applicable.
No, IPC means the public officer. Who are the public officers that is mentioned? And if a public officer issues a document, that is called public document. Now, public documents has been interpreted in a manner, if public documents are not believed, my lord, then how the person would prove their citizenship? Because everything is based on documents. And documents are issued from,
What was that public document which we misread?
my lord, before my lord, para 90 I am reading, thereafter I am satisfying your lordships, para 90. Thus a mistake on the part of the court which would include a mistake in the nature of the undertaking may also call for a review of the order. An application for review would also be maintainable if there exists sufficient reason. Therefore, what would constitute sufficient reason would depend on the facts and circumstances of the case. The words sufficient reason in Order 47, Rule 1 of the Code are wide enough to include a misconception of fact or law by a court or even an advocate, an application for review may be necessitated by way of invoking the doctrine actus cuni nemi nem grava bit. Now, my lord, I have said that subsequent developments is also a reason to review the order, my lord. Now, my lord, the NRC authority, after the supervision of the Honorable Supreme Court, has published the NRC. In NRC, my brother's name has been included. My brother's names have been has been included, and that is a good ground. Subsequent development, because when my own brother's name is included in the NRC, that should be taken into consideration also. Though at that relevant point of time, this NRC was not published. But we have annexed later on in the writ petition, in the review petition, that my own brother's name has been recorded in the NRC, so that Lordship may kindly see. That may be seen page 100. Page 100. And operative portion may be seen, my lord, page 101. Imtaz Ali. Imtaz Ali is I am Ator Ali. My father's name is Insan Ali, and Imtaz Ali is my brother. His father's name is Insan Ali, and our mother's name is Momina Khatun. So that is accepted. So, my lord, that was the result of house-to-house enumeration, man. So this is a subsequent development which your lordships may consider.
In which electoral roll the name of your brother appears along with you? Exhibited document.
Yes, exhibited documents that lordship may kindly see. Voters list are there. It's 54.
First voter list is of 2005. But whether it is exhibited document or not, we don't know.
2005. Kindly see page 62, my lord. Ator Ali, D, the letter D is there.
Just a moment.
Yes, yeah.
Can you tell us, you had a brother whose name is Shahjahan Ali. What happened in his FT case?
That information I have at present not with me. But lordship, kindly see page 67.
No, we have seen that. That's why we are asking only one question.
I have no information. I may collect information if your
No,
lordship.
it's okay.
But first of all, my lord, from the reading of the order, the judgment of the Honorable Court, my lord, we find nothing that there is error apparent in the face of the record, my lord. My lord, review jurisdiction, as your lordship knows, my lord, it's a limited jurisdiction, and it is more so, my lord, while it is the review of the order passed under certiorari jurisdiction, my lord. Even in certiorari, my lord, this Honorable Court may not go for to look the new documents before the Honorable Court. Now, my learned senior friend is asking, saying that my lord, this brother name is there in the my lord NRC. So this may be reviewed. NRC is not yet published. This argument I have already made in another case, my lord. This Honorable Court has settled. This NRC document is not yet a finalized document. It is not yet accepted document. The RGI of India has not published it NRC yet, my lord. So it cannot be accepted as a valid document as of now. This is settled by this Honorable Court, my lord, in another review petition, my lord. So NRC cannot be a ground for review at this stage. Secondly, my lord, if NRC in this said judgment, this Honorable Court, my lord, I'll submit the judgment, my lord. It is similarly, my lord, the Atar Ali, who is claiming to be brother of my lord, one person whose name is there in NRC document, even though it is not yet accepted document, my lord, that first of all, he has to prove that he is his brother. And in Abdul Quddus itself, on the basis of which they are praying for review of this judgment, my lord, itself, the Honorable Apex Court has said that review can be done if there is a contradictory opinion of the tribunal. The brother or the father whom he is claiming, they must have a different, separate opinion that yes, he is an Indian. Then only review can lie. But there is no opinion of his brother or father whom the coroner's tribunal has declared for Indian. So in that case, the Abdul Quddus will not come, my lord. They are claiming only on the basis of the Abdul Quddus, that, my lord, if there is a contradictory opinion, of his projected brother or father, then, and it, on the basis of that, his name appeared in the NRC, then there can be review or my lord writ petition. So NRC is not yet accepted document.
Do you want to consult the plan? Water. Mr. Mamul,
My lord.
in this case, you have given the list of citations. Kindly add the names of the parties. It is easier for us to find it out.
Well, definitely. My lord, I have some other submissions also.
Yes.
The Honorable Supreme Court, in the case of public works, said that for establishing the citizenship, certain documents are necessary which were published at the time of preparation of NRC. Now, among those documents, all total 15 documents were there for every person. But supporting documents were there for the married woman. So in that list, my lord, list number 3 is the land records including tenancy records of relevant period up to 24th March 1971. So land record documents and lordship 13 number document has been sought for is the educational certificate issued by board universities up to 24th March 1971 midnight. So these two documents I am having. For instance, let me kindly see now page 67, my lord.
Yes.
Here, this is the Jamabandi for surveyed villages for 1963-64. Here, Lordship would see serial number 2 Ator Ali, serial number 3 Intaz Ali. This Intaz Ali is my brother whose name is recorded in NRC. All are son of late Insan Ali. The
This is-
vernacular
This is exhibit number.
this is exhibit number exhibit 3, my lord. Exhibit 3. So vernacular is page 68. So this is one document which has the support of my citizenship.
Yes.
Next, Lordship would kindly see school certificate, which is mentioned in the NRC record, NRC records, that is serial number 13, my lord. So my school certificate is there, page 71, Lordship kindly see page 71.
Just a moment. Is there any member in your family with the same name of Ator Ali? Is your own family member having this same name? Are you aware of it?
No,
No.
Akhtar Ali, Imtiaz Ali, this is Shahjahan Ali.
Is any statement made in the writ petition regarding the discrepancy of age of Ator Ali, if any? Have you explained in the writ petition?
Yes, sir.
It's not there.
Yes, my lord, that is their test 47 candidates.
Page 47 of the writ petition.
Yes. That means it is also annexed in the review petition, page 47 of the review petition.
47.
Yes.
You have explained the discrepancy of age of Ator Ali. No. It's not there.
There are so many things are there.
No, many things are there, but the question we are asking is not there. Now we'll show you something. Come to page 67, your own document.
Yes.
Here there's one Ator Ali.
Yes.
Anyone related to you? No.
Shahjahan Ali is my brother.
No, Ator Ali. We are interested in Ator Ali.
Akhtar Ali, yes. Akhtar Ali is there.
No, who is he?
The present person, present petitioner.
And you are saying that whose name entered into in the NRC?
Imtiaz Ali.
Imtiaz Ali.
Yes. Page 100.
Okay. Now what is his so Imtiaz Ali is his name is there in Exhibit 3, correct? Now come to page 62. This is page 67 is a Jamabandi of 63. Now please come to page 62.
62.
Imtiaz Ali
Hmm.
is 20 years in 2005. So he'll be born in 1985. So name in the Jamabandi appears before birth.
No, it's 2005. Yes.
Nostradamus.
15, this Somavanti was prepared on 10/8/15.
Correct. So that is not the correct, that is not the original entry.
Yes.
Correct. So
Yes.
this means it's not a correct entry. Sorry,
We-
original entry. It is
Here,
not a
what should
original
we
entry.
see, page 68,
No, no, that's okay.
sit here,
We have a pattern of questions. Please bear with us.
my lord, there it is common, lordship is aware, very much experienced lordship, just raises names differences are common in our
No,
society.
if I am aware, it becomes a personal knowledge. I am not aware.
Because
We see it, but we are not, I am not personally aware. I have no
No.
personal knowledge. I don't deal with election
so,
materials.
no, my lord, in the name of nation, no person can be done injustice. So that is also the important provision of law. And in a foreigner's case, my lord, lordship is aware that this strict proof is not necessary, preponderance and probability. So there are no rebuttal on the part of the other side. Now all of a sudden they cannot say these are wrong, these are not proper. School certificate has been exhibited. School headmaster came and adduced evidence. I think he is the witness number. Yes, witness number 3, my lord, DW3, page 59. So many documents are not necessary, my lord. If 2 or 3 documents are genuine and believable, trustworthy,
So just, I'd like to point out, my learned senior friend is relying on the exhibit 3 and exhibit 4. This is not that, this honorable did not consider those. This
No,
honorable could
he's
consider
not-
those.
No, he's not saying that. He said that it's incorrectly considered and therefore,
But that's why I want to say, my lord, I want to say that if it is incorrectly considered, if in his opinion, my lord, it is wrong consideration, wrongly decided, they may go for appeal. Definitely, we are not on that, my lord.
My
Our
lord,
case is that, my lord, whether on that ground, if he is not satisfied with that, my lord, opinion, my lord, reasoning, and then he cannot go for review. He can go for appeal. Definitely, there is no but. But review jurisdiction, he cannot argue again the same writ petition. He is arguing the
That-
same
that
writ
is-
petition, which is not permissible in
then
writ.
why this section 114 and 47 order is there, my lord? I
No,
have
it's
to
okay.
order
You may
from
not
the
enter
honorable-
into a debate.
My
So
lord.
whatever is being submitted, you may not enter into a debate. We'll consider it.
My lord, we have got 2 orders of the Honorable Supreme Court. Honorable Supreme Court, in the case of Farida Begum, it has been said, my lord, that is, my lord, is SLP criminal diary number 27360/2018. SLP criminal diary number 27360/2018. Date of Farida Begum versus Union of India. Date of order is, my lord, 7/12/18.
What does it say?
Yes. My lord, here the Honorable Court is saying, learned counsel for the petitioner has filed an additional affidavit stating that the names of the close relations of the petitioner have been included in the final draft NRC list. Learned counsel for the petitioner further submits that petitioner has filed a claim for inclusion of her name in the final draft NRC list, but the same is unlikely to be considered in view of the declaration of the High Court that petitioner is a foreigner. Taking into account the above facts, issue notice returnable within 6 weeks. Further action pursuant to the order of the High Court shall remain stayed. So, my lord, the Honorable Supreme Court has also given some emphasis on this point that the near relatives' names have been included in the NRC. That was the submission matter. And the Honorable Court believed it. And we are submitting the same thing along with documents.
Please pass that order.
My lord?
Please give a copy of that order. We
Yes.
don't have it.
Yes. Yes, I agree. I have not only this, I have many other orders.
You'll also have to tell us whether a interlocutory order passed by the Supreme Court has a binding precedent.
No, that I am not saying, but it is at least a legitimate expectation at this point, because regarding the final order, I have no information. If your lordship is on that, then lordship may kindly grant me some time. I will collect if the case is disposed of.
Okay. we'll
And
consider-
there are other orders in case of Ohiton Nesa. That was also same thing has been.
No, if you have
repeated.
a final order, please give it to us because.
Final order, my lord, at present I do not have. I have to collect it.
Okay. So we close the matter.
My lord, I just relied the judgment of 2013 8 SCC 320 on review jurisdiction.
What-
This
what-
Kamalesh Burma, my lord.
2018,
2013
13,
8 SCC 320.
name of the parties.
Kamalesh Burma, my lord. Kamalesh Burma versus Mayawati and others. Para 20 and 20.2. With regard to my lord, the Abdul Quddus 2019 6 SCC 604 month.
2000,
19
yes,
6 SCC
yes.
604. They are para 28, my lord, on the basis of which they are asking for review mainly, my lord. Para 28, it is clear. And this honorable court, my lord, in this is review petition 184 of 2019, my lord. Review petition 184 2019. Decided on 15/12/2024, my lord.
Name of the parties. You have a
Yes.
copy of that?
Yes, Siraz Ali, alias Siraz Ali and two others.
If you have a copy, please give it to us. In your
Well, I
list
have
of
Yeah.
list of books, please give us.
I will give them. My lord, I have some other short points in this regard.
You please note it down and give it to us because we can't spare time. There's a Nagaland matter waiting, which is a priority matter right now. You just give a bullet point in your handwriting also, it will do.
Giving. But my lord, my last submission would be, my lord,
And the list of books, please give the name of the parties.
Name
It
of
is
the-
easier for us to
yes,
get.
I'll give. But if your lordship is on the final verdict of the honorable court on those matters which I have, honorable Supreme Courts, then I may be allowed some time to.
No. We would not have spent 5 minutes if we did not intend to dispose it off.
But excluding those documents, I have other points, my lord, I have already
Just
said.
note it down.
Lordship may kindly
highlight
consider
those.
this.
I believe those are there in your grounds of review.
Yes, those are there, man.
Then
And
we-
over and above, my lord, Honorable Supreme Court says a judgment that documents should be interpreted harmoniously, not in a pedantic manner which may frustrate the cause of justice. Lordship is aware about that?
What is pedantic?
Pedantic manner, not in a pedantic manner. Bit
The meaning of pedantic. What is pedantic?
that means not in a. It is the word of the Honorable Supreme Court.
Right.
No.
Yes.
Meaning.
That
Meaning.
harmoniously.
Supreme Court has used it. I
Yes.
don't understand. That is why I am asking. What is pedantic?
Pedantic, this means.
You are making submissions.
Yes, I am making submission,
So,
and my submission
what
is.
is pedantic approach?
That means, wait. Huh? But that means, documents should not be given such a excessive meaning which may cause ultimately.
No, it
The-
merely means that you are too, you are restricting it to the rules as it is.
but harmonious.
It's not
Should be
harmoniously.
language.
It's not harmoniously. That is why my brother asked you that question.
Because my lord,
We
that
deal
is
with
school
that.
document.
We deal with that word day in and day out.
But let me satisfy your lordship. There is school document that is exhibited. Headmaster has adduced evidence, but the landed the earlier order that has not been accepted. So it is not interpreted harmoniously. Man. There is
Documents are never interpreted harmoniously. You show us one decision and you get through. You see, documents are, every document has to be evaluated in its own merit. You can't be harmonious. That first note is A, second will be B, third will be D, C.
no.
And then without interpreting D, we say that it is harmonious and therefore we come to E. That can't be done.
Lordship, I am sorry. School certificate is a public document. And even there is a judgment of the Honorable Supreme Court that school certificate may be accepted even without examining the issuing authority. Here we have examined the issuing authority. That is the headmaster. Even that is not believed. So if these documents, land documents are there, voter lists are there, if are not believed, then a person, how they will prove their citizenship?
Okay.
So my humble prayer is this: the order may kindly be reviewed, and I may be declared as Indian citizen.
We'll
For
consider
the reference,
your
maybe
bullet
answer
points. Please write it down and give it to us. It may be handwritten. It doesn't
Yes,
matter to
that
us.
I'm giving after some time, maybe.
Yes, yes. Give it by
Okay.
2 o'clock. No problem. Mr. M.U. Mahmood, Learned Counsel for the review petitioner. As well as respondents are there, all of them. Mr. M. Islam, Mr. J. Pang, Mr. J. Pang for FT, and Mr. G. Sharma for NRC. Argument concluded, judgment reserved. And Mr. P. Sharma, additional statement. Okay.
All right.
Note to delay. রাখি দেব। Note to delay রাখি দেব।
Item 4.
May I please, Lordship? No, this is an application under section 114 with order 47 of CPC 1908. Praying for reviewing the order dated 4/4/2019, passed in WBC number 2076 of 2017.
Please speak a bit louder.
Well, the petitioner praying for reviewing the order dated, my lord, 4/4/2019, passed in WBC number 2076, my lord. My lord, I am perusing this writ petition minutely, my lord. Petitioner have no name along with the father, my lord. That is why the trial court, my lord, Gaunbura GP president, election officer should be examined. But except, my lord, DW1, the proceeding, no witness has been examined. So, my lord, my humble prayer, my lord, for kindly reviewing the order and remand back to the trial court for retrial, my lord, fresh trial, my lord, for examining the Gaunbura GP president along with the deputy commissioner of the concerned locality. My lord. My lord, one of the brother, my lord, is declared Indian based on the record, but those record was not furnished along with this.
Which
Petition.
brother was declared to be an Indian?
And page, my lord, 90 to 94, my lord.
Name, just give us the name.
Name is Ansar Ali, my lord.
Ansar Ali.
My lord. He is declared Indian, my lord. So, my lord, one opportunity may be
This
given-
Ansar Ali,
My lord.
have you declared his name in your written statement to be your brother?
WS is page 42 of the review petition. In the WS that was not mentioned. ma'am.
Surat Ali. Do you have a copy of his written statement before the tribunal? He's your brother. Do you have a copy of his written statement?
My lord, that was not
It's
witnessed.
not given to you. But you and your brother are very disconnected people in the family. Normally doesn't happen.
Only water is.
Since I keep myself connected with the bar, I came to know just yesterday that one of the senior counsel, Mr. K. Chaudhary, expired. So I went to him to pay my last respects. So since I'm connected, I could come to know that he has expired. And in your case, in your written statement, you don't refer to your brother. And in your brother's opinion, your name is not referred.
So, my lord, my humble prayer, my lord.
No, your prayer is okay.
you
But there must be
to-
something to show that you both have pleaded about each other. Your existence is not known to your brother. Your brother's existence is not known to you.
What all should be mentioned, but due to conducting advocate, my lord, that was-
And now at the time of distress, you all, both of you know each other. Okay, we'll consider it pass orders. Your brother's opinion is at this page 90, is it?
My lord. 92, NXRL, my lord. 92, 94, my lord.
And which page is your opinion?
Page, my lord. My lord, page 45, my lord, annexure, page 45 of the review petition, my lord. And annexure 10 is in the resident statement. Page 45, my lord.
And which page is your written statement?
The written statement is page, my lord, 42, my lord,
42.
my lord.
Where is the voter list of 1989? Was it exhibited by you?
My lord, in the writ petition, my lord, 1965, 70, my parents and grandfather, grandmother is
So
there.
89. No, we are only on one document. 89.
85 is there, my lord, not 89. my lord.
Mhm. Yes. Yeah, next week on. Have you exhibited 1997 voter list? No.
My lord. 1997 is there, my lord. Page, my lord. Page,
No, have you exhibited it?
page 70, my lord, yes. Exhibit total, my lord, I have written here, my lord, is 1965, 1970, 1985, 1990, 1997, 2005, 2011, and 2017.
Okay. Let me check it. In your this review petition or the writ petition, where is that 1997 electoral roll? Have you annexed it? No.
page 70, my lord.
70.
70. Here, my lord, Hazrat Ali, Abdul Karim, in place of M. L. Tamim. Police. Village, Talapara, Molandubi, Parpa. Talpa, Molandubi, Parpa.
Apparently, you and your projected brother are you related?
My younger brother, my lord, but.
Are you
because,
related?
In the judgment, it is revealed that my lord father says, but not, he is the
No, no,
second
father's
one.
name matching is a different thing, but are you related? You see, you have not introduced your brother till now.
My lord.
Why we were asking for only few, in this review petition, we are asking for only 1 or 2 documents. Come to page 91.
My lord.
Oh, sorry, 92. Page 92. This is your brother. Exhibit D, certified copy 1997. House number 1236, serial number 1045. Now come to your document at page 70. House number 1467, serial number 1566. You are not part of the same family.
Then after separation, my lord, that was and used to separate, my lord.
Okay, can you tell us your date of birth?
Date of birth, my lord, 29/3/1961, my lord. PAN card, my lord, it is annex PAN card, my lord. PAN card. 70. This one. In 29/3/1961, my lord, date of birth. 61 or 71? 71. No, sorry, 660. Page number. 70, page number. Page number 78, 78, 70.
Need to go. Next time when you move a matter, always keep a mathematician or a arithmetician along with you. Always keep it handy. Someone who knows arithmetic or maths must be with you. Birth date is 1961. That means you have a date of birth. It's not.
No, PAN card, my lord.
No, we understand, but once you declare it, that means you know it. Once you know it, that your birth date is 29/6/1961, you have a copy of your review petition. Come to page 25. His age is 54. Doesn't match. Even knowing your date of birth, you don't write. 2017 54. So it will be 1963. Two thousand 54. It- Okay,
Okay, one point I'd like to point out, my lord, the order was passed on 4/4/2019. And the review petition was filed in 2022 month. So lapses on the part may be seen, my lord.
Para 14, my lord, I have explained it due to COVID. Due to
COVID started from, my lord, December 2019. In fact, it's
para 15.
and para 28 of the and para 28, one line, my lord, I would like to read out. The Honorable Apex Court has said, my lord, with regard to brothers and sisters. Secondly, there is a possibility that someone of the near family member may have migrated to India prior to midnight of 24/3/1971.
that you're reading Abdul Quddus.
Yes, Abdul
Uh,
Quddus.
yeah,
Yes,
perfect.
it is there. So some may come after, some may come before 25/3/71. So each and every case has to be looked differently, man. That is the observation of our Honorable Apex Court. That's why. And secondly, as your lordship has seen, my lord, there is no disclosure either from the other side. That's why, my lord, we always urge that in WS, they have to disclose everything about their family members, my lord. Otherwise, it is not possible. They may take benefit of someone's other's judgment also, opinion also, in the similarities in the name, taking the similarities of the name. That cannot be denied. So if they disclose everything in the, my lord, WS, it's okay. If his brother's name was disclosed in the WS, then we could accept it, he may be the brother. So that aspect, that must.
Okay, that's all. Okay. Heard. Mr. B. Islam, learned counsel for the petitioner. Also heard, respondents are there. Next, by filing this application for review. Sorry, this application for review is directed against the order dated 4/4/2019, passed by this court in WPC 2076 of 2017, thereby dismissing the writ petition, which was filed to assail the opinion dated 9/3/2017, passed by the learned member, Foreigners Tribunal number 2nd, Gwalbara in FT 2 is page 45. Thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next paragraph. In the grounds of review, it has been stated that while passing the order in the writ petition, the court had overlooked, oblique ignored, the written statement filed by the petitioner, wherein it has been stated that Abdul Karim and Abdul Karim Sheikh is one and same person. Full stop. It is further projected that if the voter list of 1985 and 1997 were illegible, blurred, and incomplete, it ought not to have been accepted, and the petitioner ought to have been directed to submit a fresh copy. Full stop. It is further submitted that the concerned authorities did not furnish a copy of the electoral roll of 1985 as it was not available in the office, for which the petitioner ought not to have been punished by declaring as a foreigner. Next paragraph. Is further projected in the grounds of review that this court had erred in rejecting the documents of the petitioner merely because there has been a shifting of his residence, and it is stated that there is no law which prohibits shifting of the address of the person for livelihood. Next part is the further ground of review that the petitioner has a brother, namely Muhammad MD, Ansar, ANSER, Ansar Ali, who has been declared to be an Indian citizen by the Foreigners Tribunal number 2nd, Gwalpara, in connection with FT case number 329 of 2009, and accordingly a review is called for in this case. Full stop. It is further ground of review that the petitioner is a PAN card, income tax PAN card holder. There is name and his father's name is recorded, and accordingly this ought to have been considered as a linkage document to his father. Full stop. It is further urged in the grounds of review that the tribunal proceeded with the trial, public hearing of the case on a day-to-day basis, which is serious and unconstitutional, for which the order of this court is liable to be reviewed. Next, but the other ground of review is that the finding of the court that in exercise of statutory jurisdiction, of this court, comma, being supervisory, comma, and not appellate, comma, the court would refrain from reviewing the finding of fact reached by the tribunal. Full stop. In the said context, comma, reliance is placed on the case of Abdul Quddus versus Union of India and others. Within bracket 2019, bracket 6 SCC 604. And it is projected that the scope of exercise of jurisdiction under exercise of statutory jurisdiction is also to correct and rectify any error which is crept in the order of the learned tribunal. Full stop. It is also a ground of review that the impugned order was passed mechanically, and therefore it is bad in law and liable to be reviewed. Next paragraph. Per contra, the learned standing counsel for the FT matters has opposed the prayer made in this review petition. And he has submitted that the case of Abdul Quddus does not help the petitioner in any way. Next paragraph. Considered the submissions made at the bar as well as the grounds of review urged in the review petition. Next paragraph. In this case, the petitioner places reliance on an opinion dated page 90, 8/10/2020 to project that, passed by so-and-so and so-and-so, to project that the proceeding therein, comma, namely Muhammad MD, Ansar ANSER, Ansar Ali, was his brother, comma, who was declared to be an Indian. Full stop. On a perusal of the said opinion, comma, it is seen that the said proceeding that in the said opinion, comma, the learned tribunal took note of the various aliases of the father of the said proceeding, comma, being at page 91. Red pencil. Red and blue pencil both. Late LT, Abdul, ABDUL, Korim, KORIM, Sheikh. That part, that four names. However, in paragraph 10 of the evidence on affidavit filed by the petitioner, the various aliases of the father of the present petitioner is as follows. Page 89, red pencil. First of therefore, though there appears to be a similarity in the name of the projected father of the petitioner, but there is a mismatch as regards the aliases which are referred to in the opinion rendered in the case of Muhammad Ansar Ali. Post-op. On a perusal, next para, on a perusal of the written statement filed by the petitioner, it is noted that the petitioner has not introduced Ansar Ali, MD, Muhammad Ansar Ali is his brother. Post-op. Similarly, on a perusal of the it is also interesting to note that in paragraph 5 of the opinion dated 9/3/2017, passed in the case of the petitioner, namely Hazrat H.A.Z. A.R.A.T. Ali, the learned tribunal has referred to the cross-examination of the petitioner, and it is it would be appropriate to quote the said paragraph 5, page 47. Next paragraph. From the above, it appears that the petitioner has projected in his cross-examination that he has three brothers. That including him, there are three brothers. Himself, Motleb, M-O-T-L-E-B, Motleb Ali, and Ansar Ali, A-N-S-E-R Ali. And that the younger brother stays in Salpara, Molandubi, M-O-L-A-N-D-U-B-I. However, in contrast, the opinion dated 8/10/2020 of Muhammad Ansar Ali during cross-examination, the petitioner's projected brother Muhammad Ansar Ali states that They are two brothers, including OP himself. And OP is second. He never went to school.
It is money also petition, right? It is 7, 8 years. When you are 7, 8 years old. Yeah, each one I think.
First of therefore, in light of the contradictory statement, the said statement being the part of opinion dated 8/10/2020 is quoted below, page 92, red pencil. Next paragraph. Therefore, comma, notwithstanding similarity in the names, comma, as there is a mismatch of the number of brothers, which the petitioner Hazrat Ali and his projected brother Muhammad Ansar Ali have disclosed, comma, court is of the considered opinion that the opinion dated 8/10/2020, page 90, passed by Sundari, would not be sufficient to review the order impugned in this review petition. Next paragraph. Insofar as the other grounds of review are concerned, comma, having exhibited the documents which are not readable, comma, if the tribunal or this court, having rejected it, on the ground that those were not readable, the petitioner could have filed a review petition within the time against the impugned opinion within the time allowed. Produce the legible document. First, however, comma, the same was not done. Next paragraph. By an order, next paragraph, by an order dated 2/8/2022, comma, this court having noted that that against the order dated 4/4/2019, comma, the petitioner had preferred a SLP within bracket criminal, Diary number DIARY diary number 31144 of 2019, which was withdrawn by order dated 17/12/2019 with liberty to file the review petition. But the review petition was presented on 14/7/2021, without any explanation of the delay. And therefore, this court had directed that the review petitioner shall properly explain the reasons for such delay in preferring the review petition. Full stop. Although the said order was passed on 2/8/2022, but no explanation is forthcoming by the petitioner by way of an affidavit. Full stop. Next paragraph. Ordinarily, a review petition ought to have been preferred within a period of 30 days. Full stop. Having not done so, this court gave an opportunity to the petitioner to explain the delay. The order dated 2/8/2022. Full stop. However, said opportunity was not availed by the petitioner. Full stop. Thus, there is a clear case of negligence and laches on part of the petitioner to previous this to file this review petition. Next paragraph. It is here. Are you aware of the age of your brother, Ansar Ali? Are you aware of his
Accept this,
age?
accept this orders, that other documents are not available with us.
No, no, he's your brother. You must be aware of his age.
I got 40 years. Charlie. Mm.
89. as per opinion dated 8/10/2020, in comma, in the proceeding therein had also examined one Piaruddin Sheikh, Piyaruddin Sheikh, Sheikh, projecting him to be his cousin brother. First off, he also had stated that the said Prosodi's father had two sons, and the Prosody was the second. So therefore, even the cousin brother of the projected brother of the petitioner had disowned existence of three three sons of the petitioner's projected father. I cannot copy. Do two paragraphs. So this said part of the opinion is also quoted below together. Next paragraph. Accordingly, comma, the petitioner has failed to establish his to prima facie establish his connection with his projected brother Muhammad Ansar Ali. Resultantly, comma, the no case is made out by the petitioner for review of the order dated so and so, passed in so and so. Next paragraph. Resultantly, comma, this review petition fails and the same is dismissed.
Deeply. Deeply obviously.
We'll take a short break and
Item 5.
Meet resolution. বলছি ভাই is pending for condonation of delay হচ্ছে
Let us see your grounds of review. What is the ground on which you are preferring this review? Then we'll consider your continuation application. Yes.
We have filed one affidavit, Lordship.
Which affidavit? Filed where?
In IS bill number 186/22.
Yes, sir.
No, it's not here. When did you file it?
15 February, Lordship.
The all sides are represented. If the learned counsel for the applicant has submitted that an affidavit was filed by the applicant on 18
15 February.
15 to 2025. So the said affidavit is not on record. Expect that the said affidavit be tagged with record. List as and when the bench is next available.
What is Lordship?
Item 6.
Which page is the appointment letter of DW2?
It is not a part of my, it was not a part of my writ petition. In fact, the lordship, the matter was decided at the motion stage. LCR was also not called. Yes, lordship, may I submit?
Yes.
And lordship, the tribunal decided the reference against me basically on that issue that I have proved to, I have failed to prove linkage with my projected parents or parents. And so as to establish the linkage, a DW2 appeared before the tribunal and examined himself.
You see, we are not impressed. That's why we have not heard you. In your writ petition,
Lordship,
in your writ petition, you have annexed the evidence of DW2. DW2 says your mother died in 1965.
Yes.
Now, in the writ petition, the affidavit says your age is 52 years in 2019. Therefore, you were born in 1967. After death of your mother.
Lordship, the
This is something we find it very interesting.
copy of the, sorry, I can get the point that deposition of the DW2 and the actual age of the petitioner doesn't match. Lordship, the age,
No, please explain. You see, we are showing you the pages. In your deposition, you have annexed in your writ petition, DW2. He says your mother died in 65. We are just asking you one question. In page 13 of your affidavit, in your writ petition is the affidavit, 52 years in 2019. So 67 born.
Unfortunately, Lordship, I am extremely sincerely apologize that deposition copy is somewhere missing from my petition.
In your writ petition, it is missing.
Yes, from in my copy.
Very good.
Probably
So no ground of review. We are dismissing it.
one more opportunity, Lordship, so that I may be in a position to satisfy the court, because today I am not having the copy that is why.
No, if you don't have a copy, you should have checked it at home. In your own chamber. This is not a place to read your brief. You're just asking for one question and you failed.
No,
We are
one more thing is the Lordship. Yes, I'll go the matter. That whatever may be the age, the tribunal rejected the deposition of the DW2 merely on the ground that
Yes.
that the person who is claiming as Abdul Rahim Ahmed, he failed to prove himself as Abdul Rahim Ahmed because Ahmed is written in the exhibit L.
You see, when we are exercising review jurisdiction, we should have the documents on hand. We asked you a question whether the document appointment letter is there. You said no. And in the appointment letter, we find from the order that your name is there are three words. Ahmed is written by hand.
Yes.
We don't understand that. In an appointment letter, parts of it is either typed or printed, and part of it is by hand.
I am also not relying on my appointment letter. The issue is that I'll have to prove my identity. I have appeared before the tribunal to prove the identity. Yes, I have exhibited voter ID card, family ID card, my official identity card. And if the exhibit
In your
L-
written in your writ petition, where is the evidence of DW2? Examination in chief, where is this there?
it was also not the part of the petition, Lordship.
It's not the part of writ petition.
I did not annex because earlier it was not the part of writ petition.
It was not a part of the writ petition.
Lordship. Lordship, one more chance if Lordship is given to me, then I'll try to produce all the relevant documents by way
You
of
see the-
filing additional affidavit.
You see, the problem is that every day when we take up this foreigners matter, we say that please come prepared. We appear to be more prepared than you.
I sincerely apologize,
So
Lordship.
it's not a question of apology, it's a question of the court spending time on your matter. When we said that we have urgent matter of Nagaland state pending before us. So 3 senior counsels are waiting for the argument, and then we are taking up this matter, and you said that we are not prepared. Did we pass a dictate in the court not to read and come? In your writ petition, you have filed a affidavit where these documents are annexed.
Lordship,
Your deposition is annexed there, but you don't care to read, you don't care to see the records. You don't verify the records. Because of your non-preparedness, should we adjourn the matters?
in the interest of justice, Lordship.
For interest of justice is that you should be prepared.
No, some other documents which are also not the part of.
That's all. When you find discrepancy in your age, we don't find discrepancy in your brother's spelling. You don't get a second opportunity. We are dismissing it. We'll pass orders in the chambers. And there's a delay in explained. You have not even explained why there is a delay.
The Lordship is dismissing only because of the discrepancy regarding age. That,
But that we don't know what
no,
will
that
dictate.
ground-
When we
that-
when we go retire into the chamber, we'll think of what we see.
But this is not the ground of my review. My review is that certain documents which are not taken into consideration, and if they are considered, then result could be
You
otherwise.
see, we are now, you see, don't make us use words which we hate. We dislike using certain words because it demeans someone.
Lordship,
We don't want to use those words.
Lordship.
But please tell us, we asked you only one question. Your mother died in 65, you were born in 67. How is that possible? After that, you want us to review the order.
Lordship, that document is not part of my record. That is why.
No, I don't know. We use AI for various purposes. We reconstruct past. We want to see my happy family. I would go to an AI, reconstruct my family together. We do that. But to have yourself born in 1967 when your mother died in 65 is something very interesting. No ground of review. One wrong statement itself. And it's not one wrong statement. My esteemed brother took the trouble of reading your present review petition. There also you are 50, your age is 67 born. Your writ petition and your review petition, your age is consistent, 67 born. You can't say that I've made a review petition without looking at the age, the deposition of DW2 on which your review petition is based. Sorry, you're wasting our time in this matter.
Lordship.
Oh, disturbance.
Yes, item 2 was left out.
My lords, in item 7, my lords are referring to who was left out.
No.
Item number 2.
Oh, I'm so sorry, my lords. I'm so
It's
sorry.
okay, it's okay. Surf Excel says दाग अच्छे हैं. uh,
Take item 2, my lord. Earlier review was dismissed, my lord. It's the second that.
Item 7.
Please.
Somebody is watching you from beyond.
I think my daughter is there on the screen.
That's why we are.
Actually, she had come almost up to the airport, but she was having throat congestion.
Oh, acha,
So
acha.
she went back.
We
My
saw-
apologies, Your Lordship, for that.
No, it's okay. I just want to get an opportunity to smile and I do it. Nothing against you.
Well, I'm glad to see my lord's eyes are better, my lords. The last time there was some procedure my lord had suffered because of.
I have stepped into the first footstep of getting old. I got a cataract.
Oh, okay. But I hope better now, sir.
Yes, yes. First step to aging. Reach that milestone. Yes. Last time when we stopped, you were referring to the case of Veerappa Moily.
Please.
And then you were referring to Article 371A.
In this connection, my lord,
Veerappa Moily, what was the citation? I just forgot to note the
he
citation.
was once law minister.
No, the citation I forgot. Oh, Veerappa Moily is that, okay, that note.
Yes,
That,
law minister, he was earlier the petroleum minister.
No, I understand that the minister's note you are referring to. Okay.
No, but since your lordship has touched upon that, I will start from there. Not only we have those people who can give.
Our document. This is a part of the petition.
This document, the typed pages after this, madam. Kindly see that.
No, but can we refer it from the writ petition? Otherwise, we will find it difficult to follow this document. This document is which page of the writ petition?
What page is it?
Petroleum Minister letter dated 21st November 2013.
That's it. He's only referring to the Attorney General's advice. I'll only take your lordship to 2 paragraphs. That's all the relevance of this is.
No. we will find it later on, we'll find it very difficult to to refer to loose pages. So if we refer to the writ petition, I think that is page 178. No. Because Mr. Bhargava will have a tendency to forget.
Even in few hours we forget nowadays. This, my lord. This is the letter.
For you, it is vitamin M, which makes you forget.
Sometimes loss of memory is a great blessing.
Yes.
My lord, this letter is 13th June 2013, which is at page 178. My lord,
178 is 13 June.
13 June.
This is
This is a
21st
subsequent
November.
letter. This is a subsequent letter where he incorporates the advice and asks the government to withdraw the notification inviting expression of interest. Is this there?
Yes.
Not true. May I just touch upon the document before your lordship? That is the type page. This is 21st November 2013, madam.
Yes.
He refers to the earlier letter, which is on record, 30th July 2013. And then, my lord, he says, third paragraph, in this regard, Attorney General of India has opined that Nagaland State Assembly is not empowered to make laws in respect of mineral oil, which is specifically covered under entry 53 of list 1. However, laws made by the Parliament under 53 of the list shall have no application in the state of Nagaland unless the Legislative Assembly decides to extend the application of such laws to the state by way of a resolution. Now, this is the opinion, my lord, with great respect of the Attorney General. It's divided into two parts. According to the first part, as far as entry 53 is concerned, state does not have the power. Then the second portion is the Parliament also does not have the power to enforce any law for item 53 unless the Legislative Assembly of the state of Nagaland by a resolution so approves. Now, this is taking the matter in a slightly different way, madam. So therefore, it is neither here nor there, except to this extent that the state may not have the power and the Parliament cannot enforce it. So at least one portion is very clear. The absolute acceptance of Article 371A that any act of Parliament concerning those provisions mentioned in 371A will have applicability subject to the resolutions passed, if any, by this. So it's complete affirmation.
Now, as the second portion is concerned, there is no provision in Article 371A itself to the extent that the said provision is subject to entry 53. No such. It is very clear. Notwithstanding anything contained in this constitution, no act of parliament shall apply in regard to such and such, unless the Legislative Assembly of Nagaland by a resolution so decides. So here, I find something very curious as far as entry 53 is concerned. As far as entry 53 is concerned,
Constitution.
let's give constitution.
Constitution.
May I read it for my lords? Regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, other liquids and substances declared by Parliament by law to be dangerously inflammable. I stop here. So the first portion is the Parliament can make certain provisions in terms of 53. In those cases or those articles which are dangerously inflammable. I don't think that whether it applies or not, it would be a matter of serious contest, because if it's an inflammable thing, certain regulations will be required. Maybe international standards are there, which they can post. And the next one, my lord, regulation of mines and mineral development to the extent to which such regulation and development under the control of the Union is declared by Parliament by law to be expedient in public interest. This is important. So there must be an element of public interest. So the law which can be passed or which has been passed, it must pass these two twin tests. Dangerously inflammable, a law for that. Another, a law in public interest. In effect, what has happened here is though it is the people or the state who are the owners of this resource, being the owners, are entitled to the revenue from it. Very curiously, the revenue is being usurped by the central government in the garb of restrictions in matters pertaining to dangerously inflammable items or in public interest. How can an entity, be it the center, who doesn't own that oil, take away the revenue and exclude in this process the revenue which should have lawfully come to the state? So here, my lord, they are giving to the state a percentage of royalty. That's it. So revenue is taken by both the bidder, private party, and the central government. If they are going to defend that we can have a regulation showing a public interest, and what is the public interest here, my lord? What the framers of the amendment wanted to give to the people of the state of Nagaland, this oil. You take away their revenue, and that is being taken away by the central government. Where is the public interest, my lord, in this? Because my lord had repeatedly asked one question, which I always remember. That is there any breach of 371A by this restriction? I mean, by this regulation? So in this direction, certain agreements were executed between the government of, between the central government, Oil India, private parties, etc. Now, when you execute these agreements, you must mention about the owner of the asset, that is the state. The state cannot even sign that agreement. I am the owner,
We'll continue at 2.
please.
2:10.
I'm available. 2:15, madam.
Okay. Mr. Balgopal, I incidentally have another bench. So at 3 o'clock, we'll break this bench. 3 o'clock, we'll rise from this bench. Tomorrow, we'll continue with that. You can continue till 3.
Sorry. Minerals includes all minerals except mineral oils. Then, my lord, B is mineral oils. Mineral oils include.
You are referring to the definition of mines and minerals.
Very well. So there we don't figure because of this definition. Because at one stage they say mineral oils include
mines and
natural
minerals.
gas and petroleum.
Mines and minerals.
Very well. Well, on the sheet anchor of the submissions made by the learned senior counsel on behalf of Government of India is again on 2 counts. One, my lord, is breach of federalism. My lord wants me to read the definition of this act, my lord.
No.
So one is breach of federalism, more so in view of the fact that federalism constitutes a basic structure of the Constitution. Many of the judgments where he has said that we can call out this from here, there, etc. I'll give a treatment to all those judgments. I'll make it in a competent way. I won't waste time. In a situation like this, where the Attorney General himself, in his wisdom, states that any law made under entry 53 will not apply to the state of Nagaland. And further, 371A talks of 2 aspects. One is ownership of land and resources. Second is transfer. So ownership and transfer of land and resources. Ownership, I'll give your lordship's various judgments, starting from Anand Mills, etc. What are the rights of the owner? Also on transfer. Now here what they have done, they have claimed ownership over the resources in writing.
Yes.
And transferred the resources to a third party. Therefore, there is not a restriction, but a clear breach of the constitutional guarantees given under Article 371A. There's no second opinion on this. So if that is the position, the various decisions on which they plead federalism being a basic structure, all those decisions go against them. They have breached federalism. After all, federalism does not mean state has no right. You've taken away the assets, you are dealing it with a third party, entering into agreement. State of Nagaland does not have a place to sign that agreement. Now, my lord, I'll just for a moment take your lordships back to the 16-point agreement. I think I gave your lordships this last time.
Yes, it is.
I have flagged it for your lordships. I won't go through the whole thing. I'll just explain this.
No, we have it.
Yeah.
We have a copy.
Therefore, this is just the discussion. My lord has got. So this is a discussion with the foreign secretary along with the members of the Naga National Council also, when they were going to lay the foundation of Article 371A. Where the foreign secretary brought to their attention entry 53 and 54, even before 371A was there. And he made a statement, your future 371A, which right you are going to get, that will be subject to 53 and 54. So kindly see internal page 14, madam. Point 7. My lord has got that, madam.
Yes. You have already referred to it.
Yeah, I'm just connecting this with that, what I'm submitting now. So here there is no agreement as far as the Naga People's Conventions are concerned for introducing 53 and 54 into 371A. And this is clarified by the then Prime Minister, who said, we will not interfere. We leave it to yourselves. Last time there was some confusion on the parliamentary debates because unfortunately the pages were mixed up, which I forwarded to the lordship. I got the correct 2-3 pages. I'll take up that. Therefore, my lord, in this type of situation, what has happened to 371A? It has disappeared. No value. Nagaland is like any other state which does not have 371A. Then, my lord, what is the effect of so many legal luminaries, statesmen speaking in the parliament and bringing out the intention of the legislature as far as this act is concerned, with nobody opposing it, unanimous. Every person is welcoming that we should give it to them. It's a small state. They deserve help. They are joining us. So all that has been washed out. And we cannot forget, as I mentioned to your lordships earlier, the circumstances in which the government of India, in its wisdom, agree to give these privileges. Just for the sake of repetition, my lord, the Cold War going on between our neighbors, Pakistan, China, it's mentioned in the debate itself about China. In fact, the then Prime Minister writes a letter to the President that we are in difficulty. That's not a privileged document. And they mention about China. So in the overall, they wanted the security of the state and the Nagas were willing to step in. So they said, we will give you this. After all, what is land and resources compared to the entire state of Nagaland, compared to the security of India? That is why it was agreed. Now, with one stroke of pen, the entire affidavit, entire submissions today by the Union of India is not only contrary to this, contrary to the advice of the then led Attorney General. Now, my lord, in the last occasion, I had given the debates, my lord, where your lordship were kind enough to point out that the page numbers are not tally. Yep. One more copy. Okay, so. This is uniform. Last time there was an error from our side. The pages got mixed up. So I've just extracted that and given the correct copy of the original. I'll just read 2 paragraphs, that's all. The 3rd page, my lord, 1 paragraph. This is the Lok Sabha debate. In fact, the first paragraph, I'll start with that. Then I'll come to the 3rd page. The Nehru said, almost exactly 2 years ago, I made a statement in this house in regard to Nagaland and in regard to a certain agreements that had been arrived at with the leaders of the Nagaland, that is the Naga party, so that what we are doing today is in continuation of that agreement that we came to. It is not entirely a new thing. An agreement was arrived at and it has been acted upon during these 2 years to the extent it could be without having any amendment of the Constitution. This is very important. Suppose there was to be an exception, then they would have to put the amendment that this is subject to this or that. Then, my lord, we accepted them not fully, but we accepted it almost entirely, except for some minor changes. The 3rd page, my lord, where I've underlined, page 4528. My lord has got that, my lord? I read it. Then I would like to mention about the special provision for land and resources. In accepting these special provisions regarding the unfettered ownership by the Nagas of the land and its resources, the government has not only recognized the intensity of the Naga tradition regarding such ownership, but it has shown a magnanimous understanding in the tradition of Ashoka and Akbar that the strength of India lies in a unity in diversity. Completely they are standing by the people of the state. This is as far as the Lok Sabha is concerned. I've given the relevant paragraphs and the original debate. Now, my lord, Rajya Sabha. Maybe only Lok Sabha. Yes. Take Rajya Sabha. Give me one copy. One more copy. How many copies are these? These are copies. Yes. Don't give this. Picture. Please. Where is that last page? Okay. Right to. Second page. I will just forward only one paragraph of the Rajya Sabha debate. Then this will be over with that. My lord, may kindly take to second page, my lord. Then page 4716. Second page of this. May I read it, my lord? Anyhow, it is for the people of Nagaland to make their rules about the land. Pandit Nehru. Next, my lord. A famous lawyer, my lord, your lordship would have seen him, Ashok Kumar Sen. He has come here so many times at that time. He was a
I've not seen him, but I've heard of him.
Yeah,
He was the first law minister.
The peculiarity of him was, he was equally versed in civil and criminal law. And in my initial practice, I wanted to follow that path, to learn both. And he was one, while he's going around in the corridor, people used to brief him. And sometimes he used to get caught in the court because he would not know whether he's appearing for the petitioner or respondent. So they have to correct him, you're on this side. Genius, living genius of the time.
Somebody told me, I don't know whether it's right or wrong, but we heard that he said that if I'm briefed, I might as well argue before a lamppost.
That was said by Nariman. What,
I don't know. I've heard of him.
what
I
Mr.
don't know.
Nariman said was that if I get peace, I will appear and argue even before a lamppost. I have seen that. There were different class of lawyers at that time. Therefore, my lord, yeah. Page 4717, Ashok Kumar Sen, former Union Law Minister. The whole scheme of the bill is that no law of the central government will have automatic application to the new states. They will apply only if they are so applied by the new legislature of the new state of Nagaland. That is the whole scheme. Yeah. Therefore, my lord,
I hope by the time you end it, and your submissions, you go out with the same effect, having argued before a lamppost.
our profession is basically a profession of opportunities. If you
Very true.
get
Very-
the opportunity, all are same. We all
Very-
have the same IQ, we have the same capacity, we pass the same exam. But some people are very lucky to get a different exposure at a different stage. But all said and done, merit can never be tempered. You have to wait for some time, that's all. No other thing.
Very true.
Then, my lord, since the intention of the legislature, only on that point, I'm forwarding the Supreme Court judgment, my lord. Seven judges judgment. Abhiram Singh versus C.D. Komachan. 1 minute. Just a minute. Page what? I'm just giving the relevant paragraphs, my lord. Your lordship wants a full judgment, I will place it on record. I will give, then. So, that's it. So that this is in support of the submissions which I have made. That this is the true intention of the legislature. This cannot be avoided by any person, be he a minister or otherwise, who makes statement much after the act has come into being. Those legislatures who were party to the act, the intention comes from that. After that, so many people depending upon the government can say so many things. So this is basically to emphasize that single point. My lord, I have given Kuldeep Nair versus Union. I think they have mentioned this. Have they mentioned it? Other side has given this judgment, Kuldeep Nair versus Only one small paragraph I'll take, my lord. My lord has got it, my lord, or shall I give a? Do you have one more copy?
Which one?
That is Kuldeep Nair. They have quoted it. They have given it. Any other co- My lord has got. Para 34, my lord. May I read, my lord? Para 34. My lord has got 34, my lord.
Just 34, Article 246.
That's right. It's on page 44, para 34. Internal page,
Oh, acha.
maybe their pages might be
No,
different.
no. I'm looking at the wrong.
I can forward my copy.
No, it's okay. We have it. Two 2006-7 SCC, page 1. Yes,
Just 6 lines, my lord. 34.
yes.
Constitution legislative history. Before coming to the legislative history, we may state that the rule of interpretation says that in order to discern the intention behind the enactment of a provision, if ambiguous, and to interpret the same, one needs to look into the historical legislative developments. My lord,
No, yes, we have.
next one. The key question is whether the residence was ever treated as a constitutional requirement. This, I think, is former PM's Rajya Sabha residence, my lord. Now, 35, 36, it was observed. One of the known methods to discern the intention behind enacting a provision of the Constitution and also to interpret the same is to look into the historical legislative developments, Constitutional Assembly debates or enactments preceding the enactment of the constitutional provisions. That's all. 37 is in continuation. If your lordship mean, I can just read that also. 37, the Constitution has established a federal system of government with bicameral legislature at the center, which is not something which was grafted in the Constitution for the first time. Its history goes to Government of India Act in 1919. Even under the Government of India Act 1919, the qualification of residence in relation to a particular constituency was considered to be unnecessary. Your lordship wants me to read the whole. So this is very clear. I am only bringing this to your lordship's notice for the limited purpose that the history behind the enactment also cannot be ignored. And the history starts, it was a pre-constitutional document. In fact, I would say pre-independent document. The 9-point agreement. Then a free state, before the state was found, that document, which is a 16-point agreement. Then after the various debates comes Article 371A, which is a crystallization of the earlier 9-point agreement, which has got embedded in the later 16-point agreement, where everywhere, as far as land and resources is concerned, they have given eminence to that, because for the simple reason, my lord, your lordship is more well than I am. As far as land and resources is concerned, the people have a separate attachment to it. They would like to govern it their own way. Even we don't have real boundaries, etc. Say, okay, this is the boundary, that is how it goes on. Unlike where you have title deeds and you have the corporation drawing it, no, we don't have all that. It's space that this is mine, this is yours. and generally there won't be any dispute. So they want to carry that forward. That is why these things are enshrined in the Constitution. And even in our delimitation case, which is coming up in Supreme Court, where I've appeared many times, there also we have taken the stand that if you disturb the boundary, there will be tribal war. And in 2007, before the then Chief Justice, they stayed the delimitation process in the entire Northeast. And then it went to Supreme Court, now it's currently there, because it is a very ticklish issue. Then, my lord, what was the position, my lord? What were the benefits the people were getting? Forget the government. Prior to 2010, during these extraction of these resources. This also shows the history of why the regulations were made. Prior to 2010, this is what the Naga people were getting, my lord. 2% add-on royalty, employment to 15 Nagas, catering business, civil contract up to 5 lakhs, 1 lakh for village development, association of 1 or 2 officials of Nagaland Directorate, sharing of production data, that is, you will tell how much they are having, which was never given. Installation of early production system. When Nagaland wanted the data of Changpang Field ONGC in its internal communication to senior management, they suggested not to share, as it was considered by them as a classified data. This arrogant attitude forced the Nagaland to make its own rules and regulations. And we were given that authority by the earlier Prime Minister at that time, that you make your rules. We would not have made it. Even basic things which we are entitled to know, that was not given. And this is the paltry thing they give to a state which owns the asset, Then, my lord, your lordship had asked last time, I'll just give it to your lordship, certain questions, which I am afraid I could not answer because these were technical things. Just for your lordship wanted to know how they discover oil is there, what are the criteria. In fact, it is relevant when I went through it, even I could learn something from it. Only 2 pages. Please, madam. So what was troubling the people at that time, I will just for your lordship's understanding. In 1994, they stopped all exploration and production because they started extracting much more than what was permissible. When we asked for data, they did not furnish. We asked for royalty. I'm telling this that it was not something just like a direct hit on 371. They paid after 10 years. They didn't give then and there, but they were getting the revenue. Then, my lord, they entered Nagaland, this I'm talking about earlier period, without any license. And then they said, we are the state, we can do it. Fortunately here, the central government acted with a lot of responsibility and chided them for doing it and said, you can't do it.
Mr. Balgopal,
Hello.
I think Mr. Kohli is not available now.
No problem.
Uh, you have a copy of this petroleum and natural gas rules?
I place it out.
Do you have a copy right now?
I have, my lord. No.
Your Lordships, I'm from Mr. Vivek Kohli's office. I'm requesting AG sir to provide our assisting counsel in the court with all the papers and documents.
Everything will be given. It will
Oh.
being given, and more than what I have given to the court, I will give.
No, sir, just what you give to the court is enough. Thank you so much.
My lord, I can, your lordship require the regulation.
No, not for you, not for us, for you. For you. Huh. We have a query.
Hello.
You see, if you come to this rule 4, and onwards, rule 4 says no prospecting or mining except under a license or a lease. Now, grant of 5 is grant of license or lease.
That is for ocean.
First is for ocean, second is for the state government.
Very well.
In any land vested in the state government shall be granted by the state government.
With the previous approval of the central government. I am the one.
That's okay.
Right.
This is one, and then you will find we are omitting to read this rule, sub rule 2, and we come to this 10.
Very well. Area and term.
Petroleum exploration license and petroleum mining lease. So the query to you is, where there is already act on the rules in force, which permits you to under 5(2) by the state government with the approval of the central government, why you required another act of rules?
No, as far as this act is concerned,
You can respond it tomorrow. We are just putting a query to you
Right.
and also for Mr. Kohli to address us on this point.
that is, we are covered under these rules. That's what your lordship.
No, we are just asking you.
Right.
There is a rule which apparently permits the state government also to give a mining lease.
Correct.
So what is the purpose of having an act when there is already situation covered? So because
Covered under the rules.
under the rules.
I got an answer for it. No, it's good.
So we continue.
Looks like otherwise, entry 53 of list 1 pertains to oil field. And there is no similar provision in list 2 or list 3. Though I think entry 50,
50 is on taxation,
no,
state list.
54 has some perimeter area entry in list 2. But 53 does not have any perimeter provision in list 2. So this is Leh City field also. Though it is 371 notwithstanding anything in the constitution, 371A, but other provisions are also applicable to the state of Nagaland. So far as legislative field of legislation, entry of legislation under list 1, list 2, list 3. That is why whether how this is to be assimilated or it is to be in a disjunctive manner or conjunctive
I
manner.
will explain.
That is what we are trying to find out.
The whole,
Only we need answer.
we will find out.
We don't have the solution.
No, we'll find out. It's not difficult. Because the problem has been compounded by the learned Attorney General's opinion. And I think in all fairness, that is not placed on record so far. The minister has only given 2 paragraphs of that. If the central government places that on record, maybe that will throw light on many more things. That's very relevant here, my lord, as far as that position is concerned.
Shit. What is she done? Right there. So, we record the presence of everyone. Mr. C.T. Jamil, Leonard Amicus Curie. You see it from the last one. Is it? The submissions of Mr. K.N. Balgopal, Leonard Advocate General for the state of Nagaland, assisted by
You're giving the
T
list of
four, you're
appearance.
given, okay, list of
Given
appearance is
details
there.
by
Okay,
video.
okay. His submission remains inconclusive. This is the matter again
So, list-
on,
Yeah.
give tomorrow, 14/5/2025.
Tomorrow, this is to be continued tomorrow.
Finish tomorrow.
Any difficulty?
I was told unfortunately, the border dispute is on 16th. The officers are coming tomorrow.
Will be over, first half will be over,
Well,
2 o'clock,
very,
would be definitely free.
even the other side wanted an accommodation for today. I had said nothing doing.
It's okay, because since
We'll
we
do
will
it.
be continuing
No
to
problem.
first half tomorrow,
Great.
because otherwise we're not being able to
We'll do it.
what you call, organize our road.
No.
Okay. Anybody's present in item 2?
My lord, counsel for the High Court is also present.
Yes, we have recorded all the presence of everyone. From the last order sheet, we have recorded all the names.
Yes, yes.
In terms of the last order, that's why we did not dictate it.
Item 2 may not.
Yes, you are there.
Sorry, but I was busy other course.
That's okay. We are listing this matter tomorrow.
Item 2.
Item 2. List 2.
May please your lordship. Item number 56 is there for hearing.
455 and 56.
Yes,
Not-
there are-
I
This
thought
will
not
have to be
little-
accommodated some other
Not
day.
likely to be not reach. I
likely
think.
No,
to
it's
reach.
not likely to
That's
be.
what I'm making a mention. So let you know, 10th of June, it's not in time.
No, it is only when you privately speak to Mr. Das sitting behind, you'll come to know whether it will reach or not.
Yeah. No, I had.
We already had a talk.
I was telling Mr. Das that just when you pick up the matter will finish today because you won't get much of time today.
Some other day,
10th of June. my lord.
10th of June. Okay. 54, 55.
54, 55, 56. my lord, all the
56.
councils are there my lord, for the other items.
Okay. All sides ready, all sides including senior counsel for the senior counsel of the council for the appellants are present. As senior counsel for the petition for the appellants and Mrs. Janlan and APP are present. The positive time matter could not be taken up today. Taxpayer has agreed to by all sides. List on 10/6/2025.
Lovely.
Mr. Agarwal, by any way, was this matter heard earlier by me, by one of us? No.
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 Since the matter cannot be listed before Justice Manish Chaudhary, so it came up before your lordship.
Okay.
Because
It was a fixed
Mr.
matter, my lord, so-
Ankuman
No, that's
Gaur-
right. No,
is there.
since I,
No, it was not heard by my lord in my advertisement.
no, we are asking it because it's not the regular bench, so that's why I asked.
Then
No,
that
no,
is the
it was-
reason,
it was-
because
Okay, I
Ankuman
understand.
Bora cannot appear before
Okay,
Mr.
I
Manish.
It was
understand.
not heard by.
I can understand.
Lordship.
But Lordship, with the consent of my learned friend, my lord, I would like to mention item number 51, my lord.
51.
51. Now, my lord, here the case that he has come, and my lord, lordship has directed me to have a discussion with the IO. My lord, the IO in connection with the election duty, my lord, counting is still going on till yesterday. He could not come. I pray for some time, my lord. Kindly give it 10 days time. Let the matter be taken up after 10 days.
Lordship may fix a date, your lordship.
Yes, yes.
Please propose a date.
My lord, can it be on 29th, my lord?
27th.
27th, lordship.
Lord, can you on 20?
Okay.
Lordship.
Both sides are represented. The prayer made by Mr. Didas, learned senior government advocate. Matter stands adjourned today. List on 27
7.
5 2025.
Lordship. Lordship.
Obliged.
Obliged.
Daily list item 1 for admission.
Well, in this case, answer is not received.
The notice was issued only, the notice was issued only on 8/5. Okay, say all sides are represented. As per office note dated 8/5/2025, the records of the tribunal is not received. Next paragraph, the registrar shall issue a reminder for the records to the following email address of the learned tribunal. Sending this sending this scanned copy of the records of the tribunal in respect of case number FT 721 of 2017, para to last order paragraph. Comma, in the event the physical records cannot be expeditiously sent. Next paragraph. The learned tribunal is permitted to take assistance of the Office of the Superintendent of Police from a border Borpeta.
Yes.
Yes.
To facilitate this scanning and the scanning of the records. Next para list on 28/5/2025.
Obliged.
So the next para, the interim order passed earlier stands extended till the next date of listing.
Item 2 to item 50 for hearing.
There is order matter in supplementary.
Supplementary.
Item
There's an
number
IA.
52. Item 52.
52, man.
Yes.
It's a criminal matter. I is being filed for getting a medical report. They are questioning the medical.
My lord,
Uh,
interlocutory application is for bail, my lord, but during pendency, my lord, applicant number 1 was admitted to GMCH and undergone a surgery, my. So 52. we have filed an additional.
Just a
affidavit-
moment.
Right.
I think I like the suspension of sentence. Even now. Nabi Hussain, will you give our objection? No. Objection. Nabi Hussain. No.
Okay.
In fact, the documents that she has annexed, she has annexed medical reports of January 25. And it is said that
Which
patient
page?
is
Which page is
stable.
that?
This is in the additional affidavit.
No, we don't have that.
Acha, additional affidavit filed on, कितने file को 29th of January 25.
No, it's not here.
Acha, acha. It's not in records then.
Mean appeal.
Additional affidavit in.
In IA.
A number, IA criminal
No,
number
it's,
954.
no, it's not
2024.
available. We don't have it. Nice, so.
29th of January
January
the
to
5th.
No, it's not available. Just check it. What is the date when you file it?
29th of January 25. This additional affidavit.
Okay.
Here she has annexed a few medical documents pertaining to January 25, where it is said that she is now stable after he had a visit to the hospital.
In the meanwhile, you get, we are listing it on Monday.
Huh.
In the meantime, you get the instructions from the superintendent of district jail where is lodged.
Nagaon. I'll get the report.
Miss SSGL and counsel for the applicant submits that an affidavit was filed on
29th of January 25.
29 January 2025. In which medical documents were annexed to show that which applicant has suffered medical?
Applicant number 1, my lord.
The applicant number
Who
one
said?
has
Who is appellant number
undergone a surgery.
pistolectomy surgery, my lord.
Perineal fistula.
Pistolectomy surgery, my lord. He had gone under.
It's okay, surgery, they will understand. The said affidavit is not on record. So the agency shall tag the said affidavit on record. Next one. In the meanwhile, Ms. S. Jan Ranel, APP for the state, who has already received a copy of the said affidavit, shall obtain a report from the concerned superintendent of the district jail, Nagaon, where the petitioner is presently lodged, applicant is presently lodged, regarding his present health condition. Correct?
Not.
Next paragraph, the learned APP is permitted to send us a downloaded copy of this order to the concerned authorities to receive instructions. Next paragraph, list on next Monday, 19th.
My lord.
Not. 19. Obliged.
Obliged.
For hearing item 2 to item 50.
Item number 45. Item number 45.
Mr. Das and to all learned counsel who are appearing in the matter, or senior counsel appearing in the matter, including Mr. Kohli, we'll appreciate if with a short submissions, if you can supplement it with a written note, annexing thereto the list of citations on which you want to rely on, because the endeavor would be to close the hearing, say within 5 to 7 days or something like that. Otherwise, if we spill it too long, it becomes very difficult to keep memory of.
Thought that your lordship was another division bench. I thought to conclude my part from 2 o'clock to 4:30, but as fast as possible in this case. But
No,
sometimes
if you can supplement it
becomes,
with
yeah,
a
I
written
will
note,
do it. I will do it with a note.
because
There is
if we
absolute-
keep it for too long, then
Yes.
something fades away in the memory.
Yes.
May I, Lordship,
Yes.
just as certainly we bow to what Lordship is saying, we will do that. I was only just asking, would Lordship like me to prepare that in advance before I start my this, or at the
Depends,
end
Mr.
of my,
Kohli, I'm not very fussy on how you present it. It just has to be there so that I
so that
can-
we will give you at the end of it. That's a certainty because I had planned to do so.
My lord, why I have, each your lordship has seen, the day when I started, I have given some notes.
Yes.
So that it could be, your lordship doesn't have to write. Suppose I also have a habit of writing it, even a notice prepared by any of my junior, I have a habit of writing it. But if this notice before this court, it becomes easier.
Very easier.
Very
That's right.
easier. That's why today also, I made a note, your lordship will
Yes,
see.
we got it. Yeah,
Yes,
got it.
what is the argument that was advanced? Just to connect within 3 or 4 minutes, my lord. So that we can just go into the second note. What is the argument in advance? Please look this, my lord. So this doesn't take much time. I'll just, there are only 7 points, 8 points.
Yes.
Kindly, my lord, your lordship will recollect what was argued. First, my lord, additional document, lordship got it?
Yes.
Additional document, today's note. My lord will kindly say today's note.
Yes.
This was argued. My lord will kindly, Honorable
Yes.
Justice, Honorable Justice Nandi has got. My lord, additional documents, subsequent events can be taken into consideration by the appellate court when larger public is involved. Your lordship is recollect, that was the first. Second, respective orders dated 27/9/2023 and 29/9/2023 passed by the Honorable Court in the instant proceeding has attained finality and as such binds both the party in the instant appeal. Therefore, the preliminary report has to be taken into consideration while deciding the instant appeal. Principle of res judicata also applied to the subsequent event in the same proceeding. That is what the judgment, one judgment was relied, my lord. Your lordship is recollect that judgment. Third, argument of tainted police investigation not a new ground and the same was urged before the learned single judge. Just recollect, my lord, paragraph 55. And also we have taken into the writ petition, paragraph 39, connect in my reply. Now kindly see 4. Documents were supplied to the appellant by the learned trial court after the impugned judgment was passed. Although all the documents were in possession of the state, which was submitted in a seal cover without any opportunity of inspections. This is paragraph 44, my lord, of the affidavit, additional affidavit that was filed by the state. Now see kindly 5. The learned single judge, while deciding the case, has relied upon para 41 of Inderpreet Singh Kahlan's case, which mandates thorough, fair, it will be thorough, my lord, not through thorough, fair and transparent investigation, also followed in recent West Bengal case on mass termination in 2025. 6. The state, on one hand, has tried to defend the conduct of the IO in para 88 of the affidavit in opposition, which was filed on 28/9/2023, whereas on the same day, the state has removed the first IO from Dibrugarh PS case. Such conduct of the state is an admission of the fact investigation carried out by the first IO is a tainted investigation. Ironically, on one hand, the state has lost its trust and confidence on the first IO, but on the other hand, it is a stand of the state that this honorable court should now accept the investigation carried out by the first IO as a gospel truth. The state cannot blow hot and cold in the same breath. Now, my lord, 8, not a case of negative application of Article 16, reliance placed on additional documents in appeal proceeding only to demonstrate on the conduct of the first IO and that the investigation neither fair nor transparent. I think this was the argument that was advanced, and when your lordship were about to rule, two things were asked. One is earlier, my lord, regarding about what do you say, about the Article 14, negative equality, and one is that whether we can go into the again roving inquiry. That was the two question. I will give an answer to it. Now, my lord will kindly see. My case, I'll tell your lordship. Your lordship, this case is not, I am not harping on negative equality. Negative equality is means, my lord, suppose A is continuing in service by some means, that doesn't mean that I should be allowed to continue.
Illegal means
Illegal. My lord will kindly use the word illegal. So if I am taking the benefit of an illegal, which it should be given, then is the applicability of Article 14. Negative applicability will be applicable in the case. This is not the case. My whole case, which I projected throughout, and which the learned division bench earlier said that yes, whatever you have demonstrated, now I will demonstrate. That was demonstrated before the division bench. That is why, my lord, this 4 points was taken to 4 points was formulated. 29/9/2023 order is in argument number 2, which I have said, my lord.
Yes.
Formulated. And what they said, this investigation, the report will stand till it is decided by the outcome of this.
the
Veracity of the investigation will be decided once the writ is finally disposed of by this court. So this is what, my lord. Now, earlier note, we'll kindly take the earlier note, my lord. Please take the earlier note.
Yes.
That is on 6/5,
Yes.
6/5/2025. Page 9 kindly turned. I'll try to make it very short to show that what type of investigation was carried out. My lord, I am not saying that the statement of 161, that I am not doing, that is, let us say that is true, correct facts what they brought it. We are not disputing about it. What we are saying, how the investigation was carried out. Now I will demonstrate, my lord, to the honorable court. Yes. Yes. No, just keep it for your purpose. It is a part of the. But it is there, no?
This is the original document. We could not read which was being possible.
Which you have annexed here.
FSL report.
Yes. FSL report has been annexed. Just keep it before your lordship. Just see it at paragraph 9. Then it will be easier to connect. Later on, your lordship look into it. See page 9. We want to illustration on the conduct of the first IO. My lord, kindly see my notes at page 9. My lordship got it?
Yes. Yes.
Please see page 9. My lord, this is very, very important, my lord. There are other also material, but I will show this material, one of the material. Now, see that first. On 12/11/2016, 9 pages tabulation sheet recovered by MR number 340 of 2016. Your lordship will kindly turn to page 350. I'll be very quick. See page 350. Appeal memo. 350, man. Kindly see 350. This was shown before the division bench, the Honorable Chief Justice, while taking the matter. That is page 350. Yes, 9. It starts from page 398. 348. Kindly see 348. Lordship got it?
Yes.
Now kindly see at page 348, MR 340 of 2016. Lordship got it?
Yes.
And kindly see the date. Please note down the date. Date and time of seizure is 12/11/2016. Now, the chairman was arrested on 4/11/2016. 4/11/2016. And date of the FIR is 27/10/2016. Now, when they seizure is 340, dated 4/11/2016. Now, sorry, 12/11/2016. Lordship got it? 12, 11. Please turn to page 350. Now from 348, from description of Caesar, they cease from item number 1. See at 348, item number 1. From date of
348.
348,
Item
item number 1,
cash.
description of Caesar,
Cash.
in cash, answer script. 2 onwards, these are documents.
Yes.
Now see at page 350 now.
Yes.
See 9, serial number 9.
Hmm.
Total 9 pages of APSC tabulation sheet of combined main examination having roll number, name of various candidate, general study, general English, optional subject, 1 and 2 mentioning some marks of various subject and pinned up in a small size paper. That's what, my lord, before your lordship. Pinned up in a small size paper mentioning number so and so, Pushkar Gogoi, Dhiraj Jain, Jayanta Doloy, Hemant Jyoti Bora, packed in a medium size envelope.
This is the document which was recovered.
This is a document which is recovered, my lord.
Make a type copy of this.
Now we could not make a type copy out of it, my lord. This was before the learned division bench. They want to see. They want to see what argument. We want to know how it is not a fair investigation. So now, my lord, will kindly now say the.
Now, how we have treated
Now,
this 9
now kindly see. Now how these 9 pages were treated by this IO. First IO, my lord. Now your lordship will look into it. My lord, the kindly see the next date at page 9. See page 9, next date, which was I will correlate with this, how he treated this 9 pages tabulation sheet. 3-8.
This was not sent for FSL.
My lord will kindly, my lord, what has happened? This FSL, this 9 pages tabulation sheet was never sent to FSL.
For 1000.
I have mentioned here, for 1000 days he has not sent it.
All
Other documents has been sent.
Immediate.
But he doesn't send it 1000. 1000 days he has kept it. Kindly see. Now kindly see 3/8/2020.
Page 29.
Page 9, my lord.
Page 29.
Yes.
Yes.
3/8.
29 of the appeal memo.
My lord, kindly see 29 of the appeal memo. 29 of the appeal memo. 29. 29 of the appeal memo. 29 of the appeal memo, para G. Now, your lordship, there is a note how he dealt this 9 pages tabulation sheet. Page 29 of my memo of appeal. Lordship got it?
29, yes.
See para G. Para G.
Yes.
A meeting was conducted on 3/8/2019. Lordship got it? By
Yes, yes.
monitoring
Yes.
committee called SST, set up by the Director General of Police Assam to closely monitor and supervise the progress of Dibrugarh Police Station case number 936 of 2016. H. Immediately. Now, thereafter, kindly see, now at page 659. See 659 now. Page 659. This is the second volume. Yes. Move to photo. See the second volume, my 659.
Volume 9.
Oh, I'm sorry. Running page is 659.
Additional affidavits.
Additional affidavit, 659. 2016 or 2000, huh?
This is the FSL forwarding report, and it says this date it was received on 8/8 by the FSL. It is TFS QP 190. Page 340 connect code.
Lordship got it?
Yes.
Kindly see 659.
Yes.
This is a 9 pages tabulation sheet which I said 2016, my lord. Your lordship has said.
FSL forwarding.
And this is the FSL forwarding report. Kindly see on 26/12/2019 at page 2659. Lordship got it? 659.
Something is wrong. Just a moment. Mr. Das, please check up.
Yes.
Something appears to be wrong.
আছে না Education জানে না। তাহলে দেখা বাতাই বলে না
This is.
Your lordship's paper book is 659 it
No, there's a different document. It's a part of the High Court order. I'm just giving to you. Please check it.
yes. Oh my lord.
One page.
কেনেকে হৈছে এইটো
660
হৈছে নেকি আমাৰ
Court record of 660 years.
in the court record it is 660 I'm just correcting it 660
That's okay.
yes. So my lord, on 3/8/2019, the DGP has called for constituted committee, my lord, and they said that they should closely monitor and supervise the progress of Dibrugarh PS case. Now this SIT, this investigating first IO, what he has done, when it was seized in 2016, this 9-page tabulation sheet he has kept it. Rest, all other candidates, he has sent it to FSL. This is what we demonstrated. That is why those orders are being passed. Now, my lord will kindly see at 660. Kindly see 660, my lord.
Yes.
Now, dated kindly see 26/12/2019.
Yes.
Now, if your lordship looks into it, this is the chemical forensic has sent from so and so to the additional superintendent of police. Please find herewith the enclosed report opinion number dated 16/12/2019 in connection with Dibrugarh PS case number so and so received by the memo dated 8/8/2019 and so and so special manager. Please acknowledge the receipt. So received is 8/8/2019. Lordship got it? 8/8/2019 and the report is 16/12/2019. Your lordship will find at page 340 the report. See the appeal memo 340.
UDS 192 of 2019. This has to be.
Now kindly see 340. Yes, one second.
192.
See 340, my lord.
Paper book.
Paper book. Paper book 340. And one hand keep 660, my lord. One hand 660. This keep one hand 660 and 340.
Yes.
This is the FSL.
Yes.
My lord, Honorable Justice Nandi has got it.
Yes.
Yes. Please see the 340 right hand side, left hand side of the column. Number DFS QDS 192-2019. And if you see at 660, kindly see the number. DFS QDS 192-2019. Dated 16/12/2019 at page 660. So this is the report.
Yes.
Now see the report. This is the 9-page tabulation. See the next page 341
Onwards.
onward. 341 onwards.
The document which we have shown now.
Now the document which we have shown, that page, this is what?
The FSL report.
FSL report.
Yes.
Now you see, my lord, 341, 342, 343, up to is
These are FSL.
these are 345. These are FSL report.
On that
Yes.
document which we have submitted.
The document which we have submitted, my lord.
So this was sent on 8/8 to.
So the my lord will kindly send. See, it was sent again at page 9 on 8/8/2019.
From 660 we get.
From that is 1000 days. This was kept. And he was forwarded to FSL after 1000 days.
Now thereafter.
Thereafter, your lordship will kindly turn to next page, my lord, again my notes. Again my notes. Kindly turn to my notes. Now kindly see page 608. Annexer 32. I don't know, it can be 609 also. See kindly the order of 27/8/2019. See that, man. Maybe 609 or 608.
27/8. It's 608.
608 is tallies with me, 608. Lordship got it?
Yes.
Yes. Just, it's very interesting, my lord. Kindly see. The date, kindly may see the date, 27/8. IO Surajit Singh so and so is present and has submitted. He has completed investigation of Dibrugarh PS case and submitted supplementary charge sheet number 10 against all the arrested as well as absconding accused person. IO submitted 2 number of SS report are still pending with CFSL and FSL Guwahati with the IO undertake to submit so and so. Now, my lord, the FSL report which was holding it, that is the FSL report. Now he says he completed the investigation. Thereafter, there are the only 2 reports are with me. These 2 FSL which I have shown, my lord, that is the FSL report was pending. Now this kindly see 2019. 2019. When he sees 2016, he keeps with him. 1000 days he doesn't send it. Rest he sends for FSL. Then report was there in 2019. Lordship has seen
26/12/19.
19. Now, what was his duty? When the report was there, his duty was to collect the report, FSL report. Am I right? But immediately, he doesn't do it.
For 15 months.
For 15 months, he didn't go it. That is why, my lord, with great respect, the division, when D division had taken very seriously. He said, what is this? He has not taken. This 15 months he waited. I am asking myself, is it a fair investigation? I am not on equality, I should get the job. Fair and thorough and transparent investigation. He doesn't do it, my lord. Now, kindly see 472, my lord. See 472 from the paper book. How is 472?
Hmm. 9-page tabulation sheet for 16. So and so one collected on 5/4.
My lord, kindly see. Your lordship will kindly just start chart sheet. He has admitted at page 472.
Supplementary 11.
Supplementary 11 number of chart sheet. Kindly see. Lordship got it. 472. Kindly see 116.7.
First paragraph, very big.
You forget about the first paragraph. Please leave this first
Last
paragraph.
paragraph.
Last.
In addition.
In addition. Kindly see in addition. In addition to the facts averred in the earlier supplementary charge sheet 2 and 10 in respect of this candidate, another fact came into notice in course of further investigation is that one single estimate seat smaller in size, there are 9 loose tabulation seat. That is what 9 loose, my lord. So and so, discuss above, we also recovered and seized from the rented house of the then chairman of Assam Public Service called Rakesh Kumar Pal, situated so and so, Guwahati on 12/11/2016, MR 340 of 2016, which I have shown that, wherein the name of A21 and his old number of CC 213 appear along with 3 others. Now kindly see note down. As per the FSL report number DFS dated 16/12/2019, which is page 340, enclosed here with annexure B11. Not you got it?
Yes.
Collected. One second. My lord is. As per the FSL report number so and so dated 16/12/2019, your lordship will please mark page 340. Collected on 5/4/2021. This is an admission after 15 months. What is the reason? What is a good reason that you have collected after 15 months? Now, during further investigation. Now, my first, see, my lord, he kept for 1000 days. Now it has been sent. Now the report was ready, but he does not go and collect it. For 15 months, the report is lying there. After that, he collects it. And when he submits, he doesn't, once he collects it, he keeps it him. He doesn't submit to the court. Only after 8 months he submitted before the court. My lord, I am asking, this is what was the argument which was advanced. That are you saying that this is a fair investigation? Are you saying there's a thorough investigation? You can't say on these facts. That is why I trouble your lordship with this factual part to show. Otherwise, I can't show before this court. Now, the learned single judge, your lordship has looked into it. Paragraph some 47, 48, 49 has discussed and has said that we accept. His commands acceptance. A fantastic job has been done by the IO. This is what the fantastic job has been done by IO.
Just a moment.
Yes.
You are saying that the FSL report was 16/12.
Yes.
Page 340.
Yes.
He collected it on 5/4/21.
Yes.
This became a part of charge sheet only on 20/12/2021.
Yes.
And that too because we find the reputation criminal on the very next day.
Lordship, am I clear to it, my lord?
Yes, yes.
Page 497.
Now,
We find it separately. Page 497. Second part. What he has done? In the charge sheet, he writes already.
Yes.
and in
Page 494.
494, if your lordship looks into 494 of the paper book, kindly see 494. Kindly see 494,
Serial number.
serial number 1, 494.
Yes.
Serial number.
See, the original forensic report received from the director, chemical examiner government of Assam, right, report number dated 26/12/2019, already submitted. Lordship got it?
But
Now,
this is 464.
my lord, now this is 464. Kindly see 464.
The date.
The date of 464. Page 464.
Date
Date.
is 20/12/2021.
CD 464. Date.
Date is 20/12/21.
Yes, right.
490.
Now 497. Please come to 497. See 497.
First December.
See,
Yes.
this is 21st of December 2021.
Yes.
Last paragraph.
Now, last paragraph, kindly see the relevant reports of FSL dated 26/12/2019
You're
and
reading
numbers
where?
at third paragraph, first, second, third, fourth paragraph, relevant.
Yes, yes.
The relevant reports of FSL numbers so and so dated 26/12/2019 and dated so and have been received on 5/4/2021.
By this forwarding, he submitted the report.
Only by virtue of this forwarding report, he submitted on the same date.
But in the statute.
But what he writes,
Submitted.
in this charge sheet, he said already we have submitted.
This is the next day.
So I am not saying that your lordship will go into veracity of a report, go into roving inquiry, is not my case. What type of investigation he has carried? Well, am I clear to your lordship, madam, on this point?
Yes, yes.
Now, kindly take the note on the next point. Yes, I'll just read this, my lord. 21/12/2021. Please take
Just
the
a
note
moment.
at page 10.
Just a moment.
Yes.
Okay.
Violation of the order sheet. That is the violation of the order. 27(8).
It will 27(8) যেহেতু বলে যে immediately জমা দিব কইছে যে 27(8). So দুটো FSL segment ওতে কোন immediately জমা দিবি, but he does not submit.
Yes. Now finally see my note at page 10, 21/12/2021 from there.
Reading it, page 27.
Yes. In the pleading, in appeal memo, we have already mentioned that.
Pleadings are there from page 27 onwards.
Pleadings are there from 27 onwards. Kindly see 21/12/2021. See the notes.
Yes.
Lordship Ajay, just I read this note. FSL report dated 26/12/2019 was submitted after delay of 8 months and 17 days in violation of order dated 27/8/2019. 21/12/2021. FSL report relied upon in SCS supplementary charge sheet 11, page 464 after 5 years from seizure against previously named accused. Now, the first IO relied upon the said FSL report against previously named accused candidate, but choose not to rely upon the same against the other candidates now named as accused by the SIT, which your lordship will have. I'll show it. Several other candidates were shielded by the first IO as discernible from the 9 pages tabulation sheet analysis alone. Now, after the SIT investigation, a further 36 candidates have been named as accused from the said 9 pages tabulation sheet. FSL report on 9 pages tabulation sheet so and so. Reply of the state of the 9 pages tabulation sheet and conduct of the first IO at para 88 BCF. My lord, your lordship recollect that I have shown that paragraph 88. They have defended themselves, and that too from the taxation department. I said they have shown by a person who may have no knowledge of the investigation. But this is what they have confirmed, that no, the investigation was carried in a fair manner. Now this is important. Why they want to do it? The provision period, I say NB I have written.
Normally, there is a presumption that the income tax would know whether somebody is performing correctly. I say 26. Yes.
And the provision period respect all employee comments from the month of August 2015 for CE 2013 best. As such, 2 + 2 years could have been completed in the month of August 2019. Because my learned friend Mr. Kohli said that 2 + 2, 4 years. Provision period, it cannot be 2 years. The IO caused a deliberate delay. This is what they want to say. Nexus, a deliberate delay in forwarding the 9 pages tabulation sheet to FSL till August 2019 so as technically enable the other shielded candidate to complete the maximum period of 4 years of provision. Now, my lord will look into another material.
This document was processed, because right from Caesar till it reached its conclusion, everything we can show. This is only a illustration. There are many other documents.
Yes. My lord, I will show some more documents here. There are other documents also will not trouble. This few only 1, 2, 3 I will show it more, my lord. My lord, kindly see 3 MR now page 408. 408. 408, kindly see 408 of the paper book.
This is MR 351.
Kindly take the note and look into 408. This is MR 351 of 2016.
Rented house.
Yeah, kindly see. This is 3/12/2016. Lordship got it? Now see, my lord, I so and so do hereby search the rented house Basanto Doloi. He was also one of the accused, member of the APSC, and he is the accused in this case. Son of so and so, so and so, so and so. Now this, what the Caesar was made from this particular rented house. And what they found, kindly see description of Caesar. One, serial number 3, my lord. See, 26 number of duplicate admit card, certificate of various exam of APSC. Number 2, 13 number of various size of piece of papers where name of roll number of different candidate of APSC exam is written. Now, if you turn to 409, 3, 1 number of request letter addressing to B. Doloi, member APSC from MC Pura Guwahati regarding of David Bodloi dated 19/6/2014. And 4, 14 numbers of biodata of various candidates along with duplicate educational certificate. All this, my lord, reference after 5 years without naming any person as an accused.
So various exam.
And various exam of APSC at 408 at 1, kindly see at 1, 26 number of duplicate admit card certificate, various exam of APSC. So this
was never
my lord, they did not investigate for 5 years. They did not investigate, neither they have brought any name of any of the accused. Allegation was only brought against ADO and various candidates, but not named as accused. This your lordship will kindly see my note. Now, kindly see another example, 347, MR 347, seized on 17/11/2016 at page 379. See 379. Yes, my lord, I just sorry, my lord. My lord, 351 MR 351 of 16. My lord will kindly see at 481 of MR 351, page 481.
There was
17.2, my lord.
He refers to 351 after 5 years. But he doesn't name anybody. He relies upon 350.
Yes. This is supplementary charge sheet number 11. This is supplementary charge sheet number 11 at page 481, para 17.2. Further, the recovery of 26 number of admit cards, certificate of various examination of APSC, 13 number of small pieces of paper with MR number 351 of 2016, wherein the name and roll number of candidates were written from the house of accused Dr. Basanto Kumar Doloi, A6, clearly established his involvement in the entire episode of illegal selection of candidates in various examinations. Now kindly see various examination and procurement of government job through APSC. On a bare perusal of the said Caesar document, it is seen there have call letters for interviews by viva of various candidates for the post of ACS, Allied Service under CC 2013-2014, Agriculture Development Officer under Agriculture Department, others, where accused Dr. Basanto Kumar was also one number of interview board, hence being a number of so and so. So, my lord, investigation carried out, and when this supplementary charge sheet was filed, 11 after 5 years, this
He is
He-
relying upon this
He
document,
is relying on this document.
but not naming.
But,
anybody.
nobody, he is not naming all those accused. Why you are not naming those accused?
Kindly see next paragraph.
Now kindly see the paragraph. Shocking, next paragraph. Shocking revelation is that out of the aforesaid Caesar documents, one, that is what 351, my lord. One call letter from Viva interview for ACS and allied service under 2014 pertaining to one candidate, namely Sri Devajit Gogoi. Devajit Gogoi, bearing roll number so and so, who eventually got selection in the select list CCA 2014 at serial number 62 and under ACA junior grade category out of 176 selected candidates was also found and seized. But this Devajyoti Gogoi is still continuing his service. He is not made an accused.
Not named as accused. Next line.
This aspect of matter clearly indicates that about the secret agreement between Devajit Gogoi and Dr. Basanta Dolo is in getting the job illegally. Now this Devajyoti Gogoi has not been named as an accused and still is continuing his service. What type of investigation you have carried out? That is what we are pointing out before the court. Nothing more, nothing less.
Is it fair? It is transparent.
No, this is whether you termed as a fair, whether is a terms a thorough investigation or detailed investigation. This is totally contrary to the judgment of Inderpreet Singh Kahlon, and with great respect to the learned single judge, said that it commands acceptance. This is what we want to demonstrate before this court. Your Lordship will please take into consideration that my case is to look into it whether there is a fair investigation. My case is not a case of negative equality. Please, my lord, that's not my case. I am not comparing with other candidates who has been left out, who is continuing in job. Please don't take that, my lord, that this is my argument. My argument is show before this court. This is a test, how he has conducted. What is the bona fide of this IO in conducting this investigation? If your lordship finds that this investigation was not fair, what is not thorough, then the end of the matter. Then the discharge order which has been passed, relying as a fair investigation, appears on the face is not a fair investigation. Now, my lord will kindly look into 379, my lord. See 379. $379, my lord. This is the MR 347 of 2016. Now, this was recovered from the chamber of Rakesh Kumar Pal, my lord. Now, date is 17/11/2016. Please note that date of that time of seizure is 7/11/2016. Description of the seizure: 1. Number of diary of Government of Assam for the year 2016. 2. One piece of paper containing following word: Bharat Nara ACS main. This is the candidates. And 380 is Agriculture Development Officer. This is Mrs. Rokumani Saikia and BDO. And 2 is 18 piece of paper marked as so and so. 3 is additional certificate of Bhaskar Jyoti Das, roll number so and so. 4 is admission certificate of Vikas Sharma for combined competitive mains exam 2013 bearing roll number so and so.
This only
Now, out of all this, my lord, all this, only 4 Vikas Sharma has been prosecuted in this case. Not by the first IO, it is only by the SIT. After maybe 7 years. After 7 years. And all this has not been prosecuted, only 4 Vikas Sharma has been prosecuted after 7 years. This is supplementary charge sheet number 14, man. 14. Which this was brought by the SIT, by the third IO. My lord will kindly this now see the next.
Mark sheet and scrutiny slip seized on the very next day on 28/8/2019, while MR number after the event declared to be completed on 27/8/2019, which your lordship will find 497. Already I have shown, my lord. Already I have shown that. Now I have shown. Now allegation that has also been shown, my lord. This is your lordship will skip that. And this camouflage we have said, all these have been camouflage, all these reports that we have said.
He's going to give an impression in 197.
Lordship got it?
Yes.
Yes. Now now next kindly see OMR sheet were found missing from the strong room after 5 years of investigation. That if you see at 486, kindly 486. 486, my lord. Very, very important. 486. See at 486, 17.14. I'll just read this, man. Note kindly see. Crust of I have, your lordship will kindly mark this 17.14 at page 486. I will not read this. I have said this. So kindly see, my lord. Mark sheets. Mark sheet, OMR sheets. Kindly see my note, my lord. OMR sheet were found missing from the strong room of APSC after 5 years of investigation, which your lordship will find at 486. That is 17.14. Now, if you kindly turn to next page, although allegation note of my note. I'll read the note, my lord. This will become convenient. Although allegation have been leveled against Devajyoti Gogoi, ACS, in the 11 supplementary charge sheet, but was not prosecuted. Lordship got it? Already I have dealt with that. Allegation was leveled against Vansi Akashi Dwara, ACS, without naming her as accused by the first IO in so and so. Subsequently, after the formation of the SIT, the said Akashi Dwara has been named as an accused by the SIT. Similar allegations were leveled against one Pushkal Gogoi, Dhiraj Kumar Jain and Jayanto Doloi, superintendent of taxes, without naming them as accused. Subsequently, after the formation of the SIT, all the 3 officers have been named as an accused by the SIT, which your lordship will find at page 486. Now, although the answer sheet of 2013 and 2014 were allegedly seized by the first IO during the year 2016-17, but after a prolonged investigation of more than 5 years, the IO revealed in the SC charge sheet number 11, 21/12/2021, that 42 OMR sheet of 2013 preliminary examination, 47 answer script of 2013 could go missing with an allegation of destruction of evidence against Rakesh Kumar Pal, who was in custody since 4/11/2016. Now, all this 42 OMR sheet, 47 answer script, gone missing. But who is there are some accused. He doesn't bring those accused.
After 5 years.
After 5 years, my lord, kindly see, after 5 years. This is report he has filed after 5 years. Now, what investigation after 5 years you file a report and you say 42 OMR sheet missing is not found and 47 answer script could go missing.
Alleging against Rakesh.
Now they are alleging against Rakesh Kumar Pal,
who is in jail.
Now, my lord will kindly see. All the aforesaid facts were disclosed by the first IO in so and so on 21/12/2021 after lapse of 5 years on the very next day when the appellant has filed a writ petition 30 of 2002 highlighting the conduct of the IO in Dibrugarh PS case while serving a copy of the same to the state respondent. First IO has been named as a party in the said writ petition. What we is done, my learned friend has filed a writ petition before criminal and saying that how a selective prosecution you have done it, how selectively you have done it. So on the very next date, my lord, he files the supplementary 11. And
bringing all this into notice.
All this was brought notice to the court. Now, my lord,
To show his bona fide, that I have sent every
submission on facts. The investigation carried out in Dibrugarh PS case by the first IO and SIT is neither thorough nor transparent and fair. As such, the segregation could not have been done on the basis of a tainted police investigation. The various act of omission, commission or omission committed by the first IO makes out a case of great suspicion that a mere suspicion on the conduct of the first IO report of the IO could not prima facie commence itself as accepted. As such, the appellant cannot be discharged from the service on the basis of report submitted by the first IO. Now, submission of law point. Already I have shown it, my lord. I will not trouble your lordship, or in the Preet Callan, paragraph 41, and which is, my lord, I have shown. Later on, I will show it if necessary to the state of West Bengal case. Can I read this? Yes.
In the Singh, you are paragraph 41, you are right.
Yes, yes, correct. Paragraph 41.
Yes.
Paragraph 41. Now, my lord, number 2, kindly see. At
19 of the judgment.
or para 19 of the judgment, para 2. 2. In state of West Bengal so and so, wherein an in-depth factual inquiry reveals systematic irregularities such as malice or fraud, undetermine the integrity of the entire selection process, the results should be cancelled in entirety. However, if and when possible, segregation of tainted and untainted candidates should be done in consonant fairness and equity. My lord, this is segregation has to be fairness and equity. But when the investigation you carry out, that investigation 3 things. One is it has to be fair, thorough, and detailed investigation and transparent. But when you segregate it, this fairness and equity has to be there. The decision to cancel the selection and must be based on satisfaction derived from the sufficient material collected through a fair and thorough investigation. So my conclusion will be here. On the first point, tainted police report cannot be relied upon. If your lordship kindly turn to next page. Tainted police, page 14. A tainted police report cannot be relied upon to discharge the appellant from service. Segregation as to have made is arbitrary and violative of Article 14. My lord, I will just try to now show the affidavit. Affidavit 245. Now I'll show the affidavit of the government. First affidavit at page 245. I'll very quick, my lord. You see the note, my lord. Kindly see my note.
Yes.
See the 245.
Argument number 2.
Yes.
Yes.
Page 245. This is the first 10. We are saying that contrary stand taken by the state in affidavit of opposition and additional affidavit. They have taken a 2 different stand. Now see the first affidavit which they have filed. Page para 12.
Page 240.
Para 8 as page 245. Para 8 kindly see, Mali.
Yes.
Para 8. Page 245.
That very information.
That when information received by Department of Tax in respect of concerned tax officer and the same was verified from the report submitted by Dibrugarh Police in April 2018, a conscious decision was taken to invoke the provision of Rule 19.2 of the Assam Taxation Service Rule 1995, in short 1995 rule, to discharge the concerned officers from service. It is stated, now kindly note down, it is stated, foundation of the said decision was based on the information received and its subsequent verification from the report of Dibrugarh Police, which constituted just and sufficient reason to believe concerned officers were not qualified for appointment to the post held by them in view of serious anomalies in the process of the selection. It is further clarified that while making, this is very important, it is further clarified that while taking such a decision, the state respondent were not interested in asserting the truth or otherwise pertaining to the culpability of the concerned officer in the matter of the selection. The decision to discharge them from service was taken in public interest for maintaining probity in the matters of public employment. My lord, I have seen, see the stand which they have taken here. Stand.
Objects sought
Huh.
to be achieved.
Now, what was there? The object which they sought to be achieved was in respect of probity in the matters of employment
We don't
and
need
the
to
foundation. They said our whole case is based on a foundation. Very important, my lord. This is the stand of the government while the first affidavit was filed. Now, all different stands they are taking. Para 12, kindly see, my lord. First, second, third, fourth, fifth line. Para 12. The decision to discharge, Lordship got it?
Yes.
To discharge the petitioner from service was taken without ascertaining the guilt or otherwise of the petitioner in respect to the manner in which he was recommended for appointment of the APSC. So now, my lord, will kindly note down this decision to discharge the petitioner was taken without asserting the guilt. Now, if you turn to 247, 247, kindly see the next line. The state respondent, 247. The state respondent, while taking such decision, did not arrive at any finding about the blameworthiness of the petitioner, nor do they attribute any blameworthiness to the petitioner. In the facts, the state is not willing to keep the petitioner service. This is what they have taken. No blame. My lord, blameworthiness. Lordship got it, my lord?
Yes.
Now see. Now kindly see. Now at 14, para 14. See the para 14, first, second, third, fourth, fifth, sixth, seventh, eighth line. 8th line at paragraph 14.
Yes.
8th line. The verification. The verification finally came by a letter dated 17/4/2018 of the Superintendent of Police, Dibrugarh, sharing relevant information with the department. Prior to this, the petitioner was arrested on 22/2018. In view of this development, no order was passed in terms of so and so, so and so. So verification only came by letter on 17/4 by the Superintendent of Police, Dibrugarh.
Based on the investigation done by.
That is investigation which has been carried out, my lord,
the first time.
by the first time. Am I clear to your lordship? Now, if your lordship now, 248, para 17, first, second, third line, it is reiterated that the power of to discharge the petitioner from service under Rule 19(2) of 1995 rule was based on the information which was subsequently verified. On the basis of the aforesaid mentioned verified information, a conscious decision was taken to discharge the petitioner from service without, of course, asserting the guilt or culpability of the petitioner in the matter. Now, if your lordship looks into this, no, it is now kindly see, it is denied. Lordship got it? It is denied. It is denied that the order of discharge is stigmatic and punitive. It is submitted that Rule 19 of 1995 rules does not mandate compliance on the principle of natural justice before exercising the power of discharge. This is
not required. 14(2), no principle of natural justice.
See, kindly see, my lord. It is submitted that Rule 19 does not mandate compliance of principle of natural justice before exercising power of discharge. You invoked a rule, but now you are saying that principle of natural justice is not required. What stand? I don't understand, my lord. Now, my lord, moreover, kindly see down below in that paragraph. Moreover,
Just
in the
just a
facts,
moment.
yes.
Yes.
Now, kindly see, moreover, your lordship goes down below, same paragraph. Moreover, in the facts,
Yes.
And circumstances of the case, state respondent had no desire to carry out any formal departmental inquiry. Yeah, so this is what they stand. Now, my lord, kindly see 249. 249. 27 paragraph. See para 27.
Yes.
8 and 17. 8 and 17 are based on records.
My lord, statement made his affidavit so and true by knowledge and paid in paragraph 3 to 8. Kindly see 8 and 17. P. 17P and a paragraph 8 are to my information being based on records. See that by 214 based on records, which I believe to be true. This is from the official files. They said this is based on records. This will be, of course, on the official record. They said, this is what I am showing it. Please, my lord, keep this. What is this statement made in the affidavit? Which are paragraph? They are saying to my information and knowledge. Now, this is the first affidavit I have shown. Quickly, I'll show the second affidavit. Then I'll wrap up this particular states.
Connected to 283.
Now, see.
Starts with 250, 283 based on legal advice.
Now, kindly see. 283 is the second affidavit. Now I'll just few paragraphs I'll show, but immediately to connect with that affidavit which I have shown and saying that it is based on official record. Now see at second affidavit which they have filed. It starts from 250 and kindly mark it 283 now. See 283, the 77, paragraph 77.
Yes.
That the statements made in the aforesaid are true to the best of my knowledge and belief based on the official record and legal advice received. So all this, my lord, whatever there it was on the official record on based on the first affidavit goes to again foundation and they doesn't want to go into culpability of the guilt. No blame what is. This is what stand they have taken without going into other aspect of the matter. Second affidavit, they made a U-turn. In fact, my lord, as I recollect, while the matter, of course I was not there, I asked my learned friend, no learned single judge, when they were about to start the hearing, main hearing of the case, then the counsel for the state came and said, please give us some time to bring on record some additional documents. Court said that this is a very important matter, so we give you time to file additional document, which is on record, the order. I have shown that order, you will recollect. That order was passed. Only 18.6, 2019 order. That the court said, okay, we are allowing you, but we are allowing to the extent of only to bring additional documents. Now, when this was filed in the court, making a totally U-turn of the case, and no additional documents were brought. Kindly see, I have at least not seen any additional document bring into the court. They paragraph 44, you also recollect what they said on the last day with the seal cover, they submitted whatever the report was there, segregation, that means all it was done in a seal cover. So, my lord, now they say all this affidavit is prepared on the basis of legal advice. Now, if you see, now how in U-turn has been made from page 250, the second affidavit which they have filed. Kindly see at page 253, paragraph 8. See paragraph 8. Lordship got it? Paragraph 8.
Yes.
It is most humbly submitted. Parameters and yardstick to be applied in case where securing the appointment to a public office is through a tainted, fraudulent process shall always be different from the parameters and yardstick to be applied in any other case where the initial appointment is not fraud, clouded with the allegation of any fraud, and it is only for some other misconduct subsequent to any valid, proper initial appointment that the action is taken by the employer against the incumbent employee. It is submitted that a case falling into absolutely distinct categories cannot be considered by applying the same principle. It is submitted that the case at hand fall under the first category where the initial appointment itself is secured by fraud, illegal gratification. Now this is the allegation which has been leveled. Now they allege. Now your lordship has looked into the first affidavit. First affidavit, we said that we will not go into this. Now they have taken a U-turn and they allege that no, whatever the initial appointment which was made was absolutely by fraud and illegal gratification. Entry into the service was a fraud. This is what stand they have taken. Now, if your lordship looks into paragraph 9, that a present is not a case of dealing with those public servants whose appointments were valid, but were found to be guilty of some misconduct and discharge of their public duties, but is a case where the induction in the public office itself is tainted with fraud and illegally. In all those cases where securing of the initial appointment itself with thorough fraud, illegal gratification, it not even be permissible for any incumbent content, violation of any right, much less violation of any fundamental right, and all those principal parameters which are otherwise generally applied for testing the validity action taken by employment would neither be available nor applicable in any such case. So, my lord will now turn to page 255. Paragraph 13. As the record reveals, paragraph 13, as record reveals their appointment was acquitted, driven by fraud and corruption, all the petitioners have secured appointment to public offices by paying illegal gratification and use in criminal proceeding. I'll show it. My lord, this cannot be their stand. Their stand is all the time your lordship has heard that initial entry was totally a fraud. Colossal fraud. They have used the word as colossal fraud here. In initial entry in 2013 and 14 batch. I'll show it, my lord. Now, after that, my lord, they have made a U-turn more. They have made a U-turn because subsequently, when they have left that 9 accused person, before the second U-turn, when they brought it before the court, SIT. After SIT was formed, third IO said, these are the accused I have brought. Then the court has asked, why you left these 9 accused? You should not leave that 9 accused. Now they made a statement before the court. They said, it is on record. They said, no. What we have done it, after this B.K. Sharma Commission of Inquiry, my lord, there were more accused who was found of 2013 batch, 13 and 14 batch.
Thereafter, SIT is investigated.
Then SIT, by virtue, they investigated, which was left out. Now this SIT found those accused person. 9 was left out. Court said, why you left out this 9? No. These are 3 different yardstick we made. No. They said now it is different. These may not be an illegal. Those are omission. I will show it. It is a part of record which I brought it. These are only an omission. 3 categories we have made.
And it is only irregular.
And what they said now, my lord, they now said, this is not an illegality, this is irregularity. This is not illegal, this is irregularity. I told that day, my lord, 3 categories they made. One is that enhancement of the mark. If there is enhancement of the mark, they said that he may not be entitled to get the post of APS or the ACS, but he is entitled to get the post of allied services. Now, suppose it is 700, 650 enhancement of 50 mark, but he is entitled to get allied service, taxation, so but any other services, he is entitled. So this is not illegal, it is irregularities. This is what they are trying to say now. My lord, strange, which you want to rely? The first affidavit, second affidavit, and third you are saying something else. This is not, my lord, dear lord, please do not take it, misunderstand. This is not concept of negative equality. This is how you conducted the investigation, in which manner, and how you segregated it. Segregate.
I belong to the same category.
And if that be the case, I belong to the same category, my lord. I belong to, if your lordship looks into this petition, I can demonstrate. Later on, I'll demonstrate.
50 marks of enhancement.
My lord, 50 marks, there is an enhancement. 50 marks enhancement. So I fall under the same category. They said it is illegal. This is not an illegal, it is a irregularity.
And,
So, no, I just quick it, my lord, finish it off, my lord.
fraud has become omission.
Now,
Some other day.
yes, now colossal fraud has become an omission for them.
Illegality.
And illegality has become irregularity.
We'll continue tomorrow. Mr. Das will continue tomorrow.
Yes.
All sides are represented. All sides are represented. The submissions of Mr. D. Das, Learned Senior Counsel, assisted by Mr. S. Das, Learned Counsel for the appellant in WA 96 of (2022) remains inconclusive. List again on 14/5/2025.
Only difficulty is that, my lord, I thought I'll finish it off, but the time is the main important factor. Because again, tomorrow I have to leave an outstation and my learned friend, I'll be there first half. Second half, my learned friend from day after tomorrow he is going to Delhi, Calcutta from Chennai for his mother treatment.
Okay.
At least for 20 up to 21st.
Okay. Just remind us tomorrow.
Yes.
We'll consider.
Because my assistance, my lord, he has angered his assistance very important for me, my lord.
No, it's true. It's true.
Because
We are noticing his.
I would also, Lordship, just make a couple of requests.
Yes.
One, of course, I will request my colleague and friend, Mr. Diganta Das, to share with us those notes, whatever I've been given, maybe directly or to Dipankar, whatever is convenient. Second, Lordship, Mr. Das will take, I think, one more day. I'm trying to assess when I'll come to Guwahati. So maybe tomorrow we can get a sense of how many more councils and days are there. Then I can plan my visit to Guwahati because I would like to argue in person. Lordship.
Again, my learned friend has done discrimination. He has not come. So when I argued the matter, Mr. Kohli, you have done a discrimination. You have not come here.
I will make up for that through this bench.
No,
I'll
no.
make it clear. If required, give an affidavit that I shall make amends with my dear friend, Mr. Das.
Okay.
So Lordship is keeping it tomorrow?
Yes, tomorrow we are taking it up after the other bench because we have another bench.
Yes, Lordship.
Today's bench will continue tomorrow also.
So grateful, Lordship.
Or your lordship will take it any other date. I don't know. Or
No, what we can do is if tomorrow you have difficulty, some other learned counsel will continue the argument.
So there are a lot of, I have been told.
We will record it then.
I have been
Okay.
told my senior, I'll tell Mr. D.K. Mishra, he will be going to argue.
Okay.
Then Mr. Chaudhary is there from Delhi. He may be here also, I don't know. So there are other lawyers. I have been told there are other lawyers to argue.
Okay, we will then put it on record. When you said that his argument, submissions remain inconclusive, there you are. So, however, he submits that he has some difficulties to address the court on 15/5/2025. Stop. Next, we are considering the same. He is permitted to continue his submissions on the next date of listing and in future dates of listing. Next para. The learned counsel of Senior Counsel and the other connected writ petitions make their submissions on the next date of listing. Then you say list on 14/5/2025.
Yes.
Hello, Mr. Mishra will be appearing in item number 4 and 26. He has some difficulty tomorrow, my lord. Day after he will.
Whoever comes, because we are fixing the matter.
Because I have argued this matter, I have got other connected matter. My arguments will be same in all others so far as tainted police investigation.
Okay.
But I'll try to justify your lordship so far as the APS. In that case, I will argue in addition to what Mr. Chaudhary has argued. In addition to that, principle of natural justice, in addition to that.
Grateful Lordship, Ladyship.
I am troubling too much of notes to your lordship, too much of notes.
Everyone has his own way of some, I am not. We both are not agree by, troubled by that. You can continue it your own way.